morning. Freeze. How's it going? All right. Well, today's another day, I guess. We'll see how it goes. So yesterday had some interesting stuff in it, you know. Had that new surveillance footage of the... We already knew about it in the documents recently, the surveillance footage coming from the house up above the... where the gun was tossed with the towel. And then we also knew about the screwdriver. But now we know that it was found on the roof, as I suspected. So it was found on the roof, and so when he went to the wooded area, some people wonder why he didn't take the rifle with him. I guess it's possible he wasn't able to put it back together, or take it back apart and put it back into his pants. You know, so he put it together on the roof, but then the screwdriver was left on the roof, so he wouldn't have one to take it apart later. But when you read the messages between him and Twiggs, it seemed like he intentionally left it there, because he had scoped out the spot even before, but that could have just been the spot that he scoped out to knowing that he was going to change clothes there. Although, you know, but then I guess if he switched to shorts, why would he, you know, he wouldn't be able to do the gun thing in his pants if he switched to shorts. It looked like he changed to shorts, but maybe that's not reality. I mean, if he switched to jeans, he probably was like, oh shit, where's my screwdriver? Oh crap, I'm going to have to leave this here. I'll just come back and get it later. You know, so isn't that interesting? It's like I think there is a possibility that he intended to take the gun back apart and put it into his pants, but he left the screwdriver up on the roof. But the only issue I have, I guess, is that he looked like he was wearing shorts when on the TMZ video when he came running around the side of the back of that building. Yeah, so we got that, and today I think we're going to get to see Exhibit 12.1 that apparently wasn't accepted by the judge, which seemed really kind of odd. Well, there's nothing wrong with zooming in a little bit on something. It's just, you know, as long as you're not changing, editing, you know, people call that editing, but what editing is when you remove parts and stuff like that to make it seem different. Now, what they should have done was have the part that they're zooming in on, have the full video, and then say, okay, now here's a zoomed in version on the same video. That way you have both options on the same one. I don't know, it seems like a lot of these guys don't know what the hell they're doing, you know. It's just kind of strange. You know, like I feel like in the Koberger case, I made better videos than the prosecution had. You know, like they didn't put the same thing together the same way. It's crazy. So, anyways, should be pretty soon where there's some court feeds, I guess. Okay, yeah, it looks like it's all ready. All right, let's see. Yeah, there's no court feed yet, though, I guess. We'll just have to wait and see. Where's that one from? There was like a Reuters one that was pretty interesting. Yeah, like Reuters has this one where... Oh, hold on. Where there's people walking around. Is this one already in it? Yeah, they have the same thing.
You can do it.
Associated Press, Reuters. Must have a pool camera there too. Yep, the defense is going to say object, object, object. You know, the same objection, hearsay. Where's the actual witness? We don't have the one with the thing, with the thing, with the thing. Yeah. All right, over and over and over. There's no feed yet on any of these. $7:38. Tomorrow I think starts later in the day, like at 1 or something. Or 12 my time, maybe. Which is good, I could sleep a little bit. But hey, while you're watching today, if you have the ability to help support the channel, buy some channel memberships for other people who can't afford them, and super chats, etc. That's how this channel keeps on trucking along. We don't get the algorithmic hit that other people get. So that's it. All right. It's funny, like yesterday, when nobody else had exhibits at all, we were able to present the case while they were talking, just like they would have, but probably better because we could zoom in and do all. I knew exactly what they were talking about and looking at. But people would rather just stare at a screen and not be, shown exactly what they're saying. It's bizarre, So if you're out there and you just randomly stop by, you'll get to see stuff here that you would not see elsewhere. I can tell you that. I went there in October of last year. I have 360-degree video of the entire area walking around. Almost, I would say, just slightly short of virtually every single thing that they could possibly talk about. I have a 360-degree video of, so that we could look at it and see exactly where they're referring to. So, anyways. Yep, hasn't started yet. Well, how's it going today, guys? I have this aerial footage that somebody sent me. I think most of you have seen it. See, I think this right here, what time was this picture? I can't remember. It's a different time frame. But I think there's a really, incredibly strong possibility that this right here is Tyler Robinson's gray Dodge Challenger. And these images are like around 11:15, 11:20 something. But this appears to be a Challenger. These markings right here are exactly what are on a Challenger. Same color, has the shorter back like that. I mean, it looks exactly like it. So somebody out there was able to get the aerial. There's actually a service that has aerial, like planes that fly back and forth just over any city at any given time and take photographs. And you can it's like real, almost real time kind of ish. They're photos, so it's not real time, but I mean, like there, it just so happened on that day, on September 10th, a plane was doing, went back and forth, just taking its normal, photographs for really, current updates of different places in the country. And it just happened to fly around at like at 11. Now, the conspiracy theorists will say, see, look, well, why weren't they there right at the time? I mean, this is like at 11:28 or something. This one might be a little earlier, this one right here. And then where that's located is, that's right here. And it makes sense to the case, too. See how it was parked right there. And let me see. I think I have. And by the way, here's the plane. I went and looked up the plane. This is what the plane did. It just flew around like this. And it flew over here. This has nothing to do with Orem over here. So why did it do that? Right? So they'll go. But anyways, this is what the route the plane was doing. Yeah, look at it. So there it is. And this was at 11:28. Look at that, where it's parked right there. Top view of Dodge Challenger. This is, I forgot what year that was, but I mean, that's 2022. What was his, like 2017? Yeah. I mean, see right there how there's that little, I'm not sure what those are, like intakes. See that? Right there, one, two. Well, look on that. You can see them. There's one there and there's one right over there. So it really just feels like that's it. Okay. I mean, I just believe that is the Dodge Challenger that he was driving, and look where it fits perfectly into his final run. So he wants it kind of away from campus on the final one. Now, prior to that, he might have parked closer when he was doing his earlier surveillance, etc. But then he parks here, and the car is even facing away. So he could run to the car and then drive it away, right? So look where it would be if it was right there, and then you walk this direction, and then you turn right. You're right there where that camera picks him up at 11:45 while he's walking along the fence line. See, in this shot right here, this is 11, or I'll show you. So there he is, and look at the time right there, 11:45 and 46 seconds. There he is walking, okay? And then he walks right in front of this sawtooth fence. He's even got the slight limp going on. See that? So there he is. That's 11:45. And then again, if he was parked right there, that's all he would do is walk like this, turn right, and then he's right there. And then that shows him parked there at 11:28, but there's another time frame where he's not there, like at 11 something else. So he might have pulled the car up there after his dry run. So his car might have been parked in this area during his dry run, and you see him walking like this. And then during his final run, see, that's interesting, right? Like he could have been parked right here or somewhere on this street, right in this area. So look for that coming up. And then he walks this direction on the dry run and then comes around. But on the final run, he parked right up here with the car facing away. All right, you guys, who's going to start the show off tonight by helping support the channel by buying a channel membership or something for somebody else, or super chats, etc. That's how the channel survives. We are currently at 0, 0, 0, 0, 0 all the way across the board. So let's just say he parked right there. He walks this direction, and then goes this direction, and then he cuts down here, walks like this. Goes over this grassy area right here, over the bridge, goes through the parking lot, goes through the tunnel that's right there, comes up underneath into the parking area, and then he comes out into this little street here on campus, cuts up here right next to this building, then comes into the front of the building, then goes into that's the Losi Center building, and then goes into the Losi Center building, and then I think he came out here and then watched and listened right over in this area for Charlie Kirk to start actually answering questions, because he needed him in position where he wasn't moving. Whenever Charlie Kirk does the questioning thing, he sits down, he does not move. And once he saw that, maybe at like 12:13 or so, he turned around and then went up the stairs right over here, and then was standing right there at 12:15. Then he stepped over the wall at 12:17, and then he laid down and he put the rifle together right there. And then at 12:22, he stood up and ran over to here, and then he sort of laid down. And he started shimmying over, and then he focused in on Charlie Kirk and got him right there, right? And that's the wall of the Hall of Flags right there. Thanks, Allie Cake. Let me see if this is working. That one hasn't played yet. Guess you're the only one that heard. Yeah. Well, we have most of the Discord conversations. Have you not seen those? They released more. They sent them out, and we got the Discord conversation in the first or the second probable cause document, and then they came out in some of the other court documents later. Yeah, I think it's like right here. Here's the text message.
Drop what you were doing. Look under my keyboard.
I put it to AI voices, right? But listen, you can listen to it.
Drop what you were doing. Look under my keyboard. I had the opportunity to take out Charlie Kirk, and I'm going to take it.
What? You're joking, right?
I am still okay, my love, but am stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but I gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you.
You weren't the one who did it, right?
I am. I'm sorry.
I thought they caught the person?
No, they grabbed some crazy old dude, then interrogated someone in similar clothing. I had planned to grab my rifle from my drop point shortly after, but most of that side of town got locked down. It's quiet, almost,
right
enough to get out, but there's one vehicle lingering.
Why?
Why did I do it?
Yeah.
I had enough of his hatred. Some hate can't be negotiated out. If I am able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you by midnight.
All right. Stay safe. How long have you been planning this?
A bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it. 3 hours ago, there was an officer with a canine walking nearby the area, hoping that pooch has a bad sniffer. I'm wishing I had circled back and grabbed it as soon as I got to my vehicle because it sounds like the police couldn't get in for a long while because of the traffic. Needless to say, I'm gonna be late coming home. Might be.
Just stay safe.
I will. I'm
funny.
more worried what my old man would do if I didn't bring back Grandpa's rifle. He's far scarier than any Fed. Not gonna lie. Guess I'm just sitting in my car, watching reels for another hour, hoping this guy fucks off.
He's right there.
Are you
That's him waiting in
okay
his
still?
car, right there.
Yes, checking spot again now. Will? I'm wishing I had
spot
circled
again.
back and grabbed it as soon as I got to my vehicle. I'm worried what my old man would do if I didn't bring back Grandpa's rifle. I don't know if it had a serial number, but it wouldn't trace to me. I worry about prints. I had to
Can you
leave
guys
it in
just
a
listen
bush
to it
where I
instead of
changed
complaining and
outfits.
bitching all the time?
Didn't have the
It's
ability or time to bring it with.
Stupid
I
sounding,
might
sure.
have to abandon it and hope they don't find prints.
Lord.
How the fuck will I explain losing it to my old man? Only thing I left was the rifle wrapped in a towel. Remember how I was engraving bullets? The fucking messages are mostly
Yeah, I
a
think it's
big
funny.
meme. If I see notices bulge ooh-woo on Fox News, I might have a stroke. All right, I'm gonna have to leave it. That really fucking sucks.
There he goes.
Judging from today,
Took off.
I'd say
what he's
Grandpa's
talking
gun
about.
does just fine. I don't know. I think that was a 2K scope. Delete this exchange. My dad wants photos of the rifle. He says Grandpa wants to know who has what. The feds released a photo of the rifle, and it is very unique. He's calling me right now, not answering. Since Trump got into office, my dad has been pretty diehard MAGA. I'm sorry, but I think this might be it. If the way is clear, I can try and come your way to say goodbye. After that, I have a spot in mind that I'll call the police to.
Are there cops outside? And why are you calling the police anywhere?
Not yet, but I have no doubts they will be on me within the hour, and I will be giving my location up and going out on my own terms. I have no intention of being drugged through the courts in front of the country. Can I come see you?
That didn't go
After
well.
that, I can call my dad and see if he's willing to help me or not.
I'm just at my parents' right now. Maybe I could make an excuse to head home for a bit.
You would need to do that right now.
Any ideas?
You would need to do
For
that
an
right now.
excuse? I don't know. For getting out of this? None. Short of my family being willing to cover for me, I am fucked.
I'm not gonna be able to leave. What's something urgent I would need to leave for?
You could say, I told you there's an emergency at home that I need you for, with few details.
I said I'm swapping laundry, heading home now.
What's up?
Nice. I will see you soon. Coworker has just sent me the still of me on campus. What is your ETA?
Like 3 minutes.
I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. You are all I worry about, love.
I'm much more worried about you.
Don't talk to the media, please. Don't take any interviews or make any comments. If any police ask you questions, ask for a lawyer and stay silent.
I don't know. I mean, it could be that the only option in this case where there's something else is like maybe his furry group of friends. I don't know. It seems like they didn't know, though. You know, why would he type in, hey, sorry for what I did, that kind of thing in the Discord. So I don't know. I think what it was is they all hated Charlie Kirk and they would talk about him, but Tyler Robinson's the one that acted out on it. I think if they had other information that Twiggs was a co-conspirator, he wouldn't have got a deal at all. There's no way. They don't need Twiggs. Twiggs isn't somebody that needs to be a witness in the case. They've already got the Discord chats and all that shit. Yeah, it looks like we've got the... I'm not sure. Which one is this one? I can't remember which screen it is. Hold on. I'm trying to get the one that's not screwed up again. Ah, there you go. Yeah, I've got everything marked out here. There's where they're going to show this video probably. Where I think we're finally going to get to see, but it's going to be really crappy because for some reason they have to just film the screen instead of like transferring the feed to whatever the feed is that the pool camera is using. I mean, it's just, So what happens is, this is what the quality is, what we get. So first of all, there's a video that's probably pretty close to first generation video, meaning it hasn't been altered much, other than maybe saved one time. Then it's played out and that compresses the video, and then it adds little slight artifacts. Who the hell knows? And then you put it, not when I say artifacts, I mean like little pixels shift around and stuff. And then we have what we got is it's being filmed on a screen. Yes, it's being shown on a screen, I mean. And then the camera in the courtroom is filming the screen, which just dramatically shifts the quality that we get to see. I mean, dramatically at that point. And it's at an angle, at a 45-degree angle. So now it squishes everything. And then I have to then capture that. And then you bring it into, it just sucks. But at least it's still viewable. It's just nowhere near the same quality. But hey, guys, I could really use you guys' support when we do these shows. We're currently just struggling again. That my channel isn't like the others that get 15,000 watching, and it's like, ooh, and they're not being shown anything of value by the person giving it to them. They're just cool, and I'm not, So whatever the hell it is, I don't know. So if you like my channel and you want it to keep it going, then I'm going to need your guys' support when we do the shows. That's it. Hello, we say howdy here. You're supposed to say howdy, not hey, hey. You said we say howdy here, and then you say hey, hey. I think this is going to be an 8-hour day of just... Yesterday we were already way ahead of this. What's egad mean? Egad! God, what kind of lunatic types that in? Let's see. We've got Twigs won't be wearing his furry outfit. That's for well. I don't think he's not going to be in court.
Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grumander, Ryan McBride, David Sturgill, Lauren Hunt for the state, Jeff Gray, the county attorney, as well as Chris Miller are also present.
Good morning.
Good morning, Judge.
Good morning, Your Honor. Good morning, Your Honor. Good morning, Your Honor.
All right.
Kathy Nestor, Michael Burt, Richard Novak,
turn up the
Stacy
volume.
Visser here for Mr. Robinson, who's seated to my right.
Good morning, counsel. Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of victim representative, Ms. Erica Kirk. Good morning. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices. All right, is it the audio working?
Sorry, Judge, the WebEx audio is not working.
All right, well, let's just take a brief moment.
It's working now.
And just let me know when it appears to be working. While we're waiting, if you have any water bottles or such, feel free to drink them. It is a little bit warm in here today, so I will be drinking from my water, so don't hesitate to use that if you need to.
Well, he might have to. I think Twigs might have to show up at trial. He doesn't show up at this one, but he does have an immunity deal. Now we've already gone over that many times. It's actually a limited immunity deal, also.
Is it working?
It's not working, but we can just keep going.
Can you send them a link to the where this is being streamed so they have something to look at?
Yeah, it's just,
I see. All right. All right, let's go ahead and continue. And let me repeat it, just because the audio may have cut out. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and still photographer, and I will invite you to come forward. All right. The purpose of this is to ensure clarity regarding the expectations governing today's proceedings. Could you both state your name for the record?
Yes, Trent Nelson with the Salt Lake Tribune as the pool still photographer.
John Wilson from KSL Television, video photographer.
Good morning to you both. Have you reviewed the court's standing decorum order?
Yes, Your Honor.
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No.
Do you anticipate any difficulty complying with the order or with the court's instructions?
No.
All right. Well, thank you. I appreciate your
Thank you.
cooperation today. As we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly during all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during today's hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or opposing to any person connected with this case, or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Turning now to counsel. Before we begin, I wish to acknowledge the professionalism, civility, and competence demonstrated by counsel for both the defense and prosecution during yesterday's proceedings. It is evident to the court that each of you approach this matter with seriousness, preparation, and a deep commitment to your respected responsibilities. The court appreciates the care which you have taken in advocating for your positions and the respectful manner in which you have done so. Thank you. Do either party require the benefit of the record before we proceed?
The state does, Your Honor. Mr. McBride will address the court.
All right, and just as a reminder, the microphones at counsel table are turned off to prevent the inadvertent capture of any communication, so if you would like to come forward, thank you. And turning to Mr. McBride.
Thank you, Your Honor. Before this hearing, the defense moved to find Article 1, Section 12 of the Utah Constitution, Rule 7B, and Rule 1102 unconstitutional as it relates to the admissibility of hearsay and reliable hearsay at this hearing. The issue was extensively briefed and argued. The court denied the defense motion to exclude the use of reliable hearsay at the preliminary hearing. That ruling is at docket number 631. In addition, defense counsel filed a standing objection on July 3rd. That's docket 678. The standing objection reasserted the arguments made in defendant's previous motion. Defendant continues to make these same objections throughout the testimony of each witness. I believe both the state and the court and everyone present knows that the defense objects to the use of hearsay or reliable hearsay at this hearing. On the point of preserving the objection, that has been done. Defense counsel has filed their motion, they filed their standing objection. Throughout the proceeding, they have continued to make objections. At this point, further objection is unnecessary to preserve the record and causes undue and unnecessary delay. This is needless delay, and we'd ask the court to acknowledge and the record to reflect the standing objection. And we also ask the court to give an instruction that continuing objections on this ground are unnecessary. Of course, if it relates to some other ground or is some item that's particular to a particular statement, that objection may be appropriate. But at this point, we feel that the repeated objections that have been made and already been ruled upon are unnecessary and cause undue delay.
Thank you, Mr. McBride. To defense.
Good morning, Your Honor. Michael Burt for Mr. Robinson. We have no objection to that procedure. As long as the court makes a ruling that the objections are preserved, we do think it would expedite matters if we didn't have to repeat the standing objection. There may be particular objections that are not covered by the standing objection we've made, and so we ask permission to be allowed to make those objections as needed.
Thank you, Mr. Burt. Thank you to both sides. I appreciate the presentation and your argument about this. The court takes no position in regards to whether the objection is made again and again or not. I leave that to the parties. I recognize the need to expedite this, and if both sides stipulate, I will adopt the request that the standing objection as it relates to 1102, Article 1, Section 12 of the Utah Constitution, and all relevant authorities that have been cited have been noted, and the standing objection by defense is in place. However, if defense feels the need to do that in order to protect the constitutional rights of Mr. Robinson, the court will not prevent that, nor stand in its way. This court is not is acting in the role of a magistrate and will allow the parties to move forward as necessary. But as noted, I will make that note that the standing objection has been noted for all of the yesterday's proceedings and will be in place throughout the rest of the preliminary hearing. Anything further or any need for the record given the court's statement?
Not from the state.
No, Your Honor.
All right, thank you. All right, the court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. And again, I will leave it to the parties to monitor the courtroom to ensure that if a witness has come in, and they shouldn't be, that they are redirected. I invite Agent Hull to return to the stand to resume direct examination. And Agent Hull, you are still under oath. Mr. Sturgill?
Thank you, Judge.
And before we begin, is there a way to dim these lights just a tad like we did yesterday? Perfect, thank you. All right, as of yesterday, there is also a water bottle to your left. And if you wouldn't mind just making sure that microphone is directly in front of you, we want to make sure that the record picks up your testimony today. Mr. Sturgill, your witness.
Thank you, Judge. Agent Hull, we're going to return to what has been marked State's Exhibit 12.1. There was reference to it yesterday. And I'd like to ask you again, have you reviewed that exhibit?
Yes.
And if you wouldn't mind, just briefly remind us what that exhibit consists of.
The exhibit is a compilation or a running of a summary of videos from UVU campus security footage contained.
Okay.
Your Honor, excuse me, we can't hear the witness.
And that's what I hear. So let's go ahead and stop. I'm not hearing it, so I'm going to have you repeat. Let's test it. Go ahead.
Check.
All right, I believe that. Thank you. Mr. Sturgill, if you wouldn't mind restarting.
I can do that, Judge.
Thank you.
Maybe bring the mic from the base a little bit closer to you. I don't know if that'll help.
We know.
All right, let's go
Cindy.
ahead and go back to what's
Man,
been
God,
marked
you
as
have to
State's
type
Exhibit
in
12.1.
Every word.
I'd asked you a moment ago if you'd reviewed that exhibit.
Yes, I have.
Okay. And,
Hey, there's a
would
flag
you just
behind him, you
remind
guys.
us,
There's a flag
what
behind
that
him.
exhibit consists of?
It's
Look,
a
he's got a-
compilation of videos
got a tan
that were
shirt.
part of the overall footage that was obtained from the Utah Valley University as part of the investigation.
And does that compilation video, from your point of view, capture Mr. Robinson arriving to and visiting the UVU campus
It does, yes.
on September 10th through the 11th, 2025?
Correct.
Okay, and again, I asked you this question yesterday, but did you prepare that video compilation?
See how
I did
typed
not.
12.1
Okay, do you know
in
who
the
did?
chat. I already know.
The Utah County Attorney's Office.
Does that video, and I'm referring to 12.1 exhibit, State's Exhibit 12.1, does it include all of the footage collected by the SBI from UVU?
It does not, no.
Does that video,
Oh, wow. There's even more.
again, 12.1, include all of the footage you collected from UVU that captures who you believe is Mr. Robinson walking around campus?
Not all of the footage, no.
Wow.
You reviewed this compilation with Mr. Olson,
There's
correct?
even more.
Correct.
And in its entirety.
Yes.
And he actually, and then you collected an 1102 statement from him.
I did, yes.
And I believe that has actually been admitted into evidence as State's Exhibit 12.3. Did Mr. Olson refer to that exhibit, 12.1, in his statement?
He did, yes.
Okay. 12.3. I'm going to put on your monitor State's Exhibit 12.3, and I'd ask that you scroll down towards the very bottom. And I would ask that you read from the statement specifically what Mr. Olson said about State's Exhibit 12.1. And I want to narrow your focus, so I'm going to draw your attention about 3/4 down the page. There's a sentence that begins on the left margin, "I have reviewed." Do you see that?
I do, yes.
Okay, would you please read that sentence?
I have reviewed State's Exhibit 12.1, and the recordings are true and accurate, including timestamps, dates, and camera labels. The only changes are some zooms and red highlights, which were not part of the original recording. Would
Have
like me to-
you, I'm sorry?
Sorry, I didn't know if you wanted me to continue. Or...
No, that's good enough. Have you had a chance, well, you reviewed the raw footage yourself, is that correct?
Correct.
And does that comport with your viewpoint of that exhibit?
It does, yes.
Have you had a chance to review what's been marked as State's Exhibit 12.4?
Yes.
Okay, and when did you review that exhibit?
This morning,
And who did you review that exhibit with?
with Kimberly Durfler.
Okay, was there any conversation about that exhibit?
No, I was just shown the video.
Okay. Nobody asked you questions or suggested anything to you?
They did not know.
Did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked State's Exhibit 12.4. What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as State's Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.
They're going to take a
Judge
5-minute break so the
State,
judge can watch
would move
it.
to admit
And they're going to
what's
admit
been
it.
marked State's Exhibit 12.4.
Your Honor, we just object to the publication of this for all the reasons we argued yesterday.
Good
We think
Lord.
this video is going to play a big role in the trial, and to allow the public to see it now would
Hey, thanks so much,
seriously impact
Phyllis
our ability to get a
Watson.
fair trial, and we're asking the court not to publish it.
It's been a slow day today.
Mr. Sturgeon, and to all counsel.
Thank you.
As it will apply to all counsel, when you are moving a piece of evidence, it's the three parts, whether admissibility into the record,
Right.
to be published in the courtroom, and captured by the
Right.
media. So, Mr. Sturgill, as it's your request, what are you requesting?
I want the media to see it.
First of all, clearly I'd move to admit the exhibit. I'd ask, and Judge, the presumption is that this is a public record and should be published. And so the state's position is that it should be published here in the courtroom, and it should be published in such a way that the media can capture it on video.
All right.
There's no reason not to. They've already shown
You
the
may,
car.
if you would approach the lectern, please, and state your name.
I'm David Ryman. I represent the news media. I did
Good.
make an appearance because the news media technically aren't parties, but as you know, they do have the right to
He
be
was
heard
great
on issues
yesterday.
like this, and I've tried to keep
This
that to
guy.
a minimum. But since this is the first one coming up today, I thought it might be helpful to just address it again. There is a presumption not just that it be published in the courtroom, as we talked about yesterday, because the participants or the spectators in the courtroom.
The video should be released.
Have a right to know what the court is viewing so that they can understand how you're making your decision. This seems like a very important piece of evidence. It doesn't seem like there is a basis to keep the people who are in the courtroom today from understanding why it's being introduced. It is not like the videos yesterday, and my understanding at least is, and you can correct me if I'm wrong, but we didn't object to the videos that weren't published yesterday that were graphic. We didn't object to the non-publication of the autopsy report. The argument here that Ms. Nestor just made is this seems really relevant, and that is precisely why it needs to be public. With the last thing I'll address is just EMC.
It's 5 minutes of him walking around campus.
It's a rule
Cindy.
presumption, not a constitutional one, that EMC is allowed. And I think that for all of the reasons that we've briefed this for your honor several different ways, there needs to be a really good reason why. If it's being published in a public proceeding in the courtroom, it should not also be, it should not also be allowed to be published to the media. So,
Thank you.
thank you.
That guy had a great
Mr.
argument yesterday. He's
Sturgill, you wish
shifted
to
the
respond,
judge's opinion.
or perhaps give a little bit more detail on what this video purports to show.
Well, do you want me to proffer that, Judge, or have the witness?
I'll defer to you.
Okay. Well, first of all, if I could take one step back. Let me ask you, I may have misheard, but let's just be clear about this video, the compilation video. It includes video surveillance from UVU campus from what dates?
September 10th, 2025 into the morning of the 11th, 2025.
So they must have him driving around
And
campus.
if you wouldn't mind just describing
Early in the
a bit more
morning. That's
detail,
crazy.
what this compilation includes.
The compilation shows the movements of the individual believed to be Mr. Robinson on Utah Valley University campus, arriving and leaving in a vehicle, arriving and leaving on foot, and then returning and leaving, and then attempting to gain access again in a
I wish
vehicle.
I had all this. Yeah.
And his movements throughout the day are included in the videos also.
Is there any footage of
Other people?
the alleged shooting?
There is not, Judge.
Okay, I just wanted to clarify that. Ms. Nestor, given that additional information and anything further from defense?
Your Honor, Mr. Burt's he's the one who's been litigating all of the First Amendment issues, if he could address Mr. Ryman's argument.
Yes, Mr. Burt, if you wouldn't mind coming forward.
See, that just shows you how scared they are of something like that out there.
Judge, I wanted to clarify one argument that was made by
Candace Owens
counsel for
doesn't
the
want
media
this
yesterday,
released.
and that was the rules, the Rule 4-202.02 does not apply to the situation we're in right now, and that is wrong. The rule says that this rule applies to the judicial branch.
Well, they didn't get out of the way.
4-202.02J says the judge may regulate or deny access to exhibits to ensure a fair trial. So I think that rule does apply to our situation, and the Supreme Court in the Algier, ALLGIER case, 258 Pacific 3rd, 589, applied the rule in the context of an evidentiary exhibit. And I know the court has not mentioned, since counsel made that argument, this particular rule, but I think it does apply here. And also applicable is the Supreme Court's decision in the Kearns case, which we talked about when we argued the motion for denying access to the cameras. And that case, Kearns versus Tribune Corporation, 685 Pacific 2nd, 515, says that the standard the court ought to apply in determining whether an exhibit at a preliminary hearing should be sealed is one of a, quote, realistic likelihood of prejudice. And we rely on the evidentiary showing we've made in connection with our motion to exclude cameras, that there is a realistic likelihood of prejudice in this way.
Over and over again.
The court knows and has access to the media coverage up to the time when we litigated the motion concerning closing this hearing to the cameras. And the court knows that one feature of the media coverage has been a very pro-prosecution bias of every story that has been published on this account. The court also knows from that coverage that information is being widely disseminated, and you have found in connection with the shackling issue that the publicity in this case is likely to reach jurors who will be part of our jury pool. And we've also submitted to the court a public opinion survey, which shows that the prejudicial publicity that the media has already generated in this case has affected the jury pool. And so those are all factors the court can point to and rely on and conclude that publication of this particular exhibit should not be allowed because there is a realistic likelihood of prejudice to Mr. Robinson's right to a fair trial. So under that standard and under the rule, the court ought to deny publication.
Thank you, Mr. Burt.
Thank you.
Any final argument from the parties before the court issues its ruling?
I don't think he heard a word he said. He's going to allow
Yes, you
that.
may.
Oh, good. He's back.
Thank you, Your Honor. David Ryman. I just wanted to clarify. I don't know that Mr. Burt and I necessarily disagree about what he said about the rule. What we were talking about yesterday was something different. That is the portion of the rule that classifies records that are in the court file. You know, it's not the same as what happens in a public hearing. And Mr. Burt referenced the portion of the rule that essentially just tracks the constitutional standard, which of course, you know, controls here as to whether in this public proceeding it can be closed in any way, and non-publication of
We heard what he said,
exhibits as a
Robin.
form of closure. So I don't necessarily disagree.
It's just
I would
a
just
stupid-
underscore
They've repeated
a
this
lot of what
50
Mr.
times,
Burt just said
Robin.
has been
Go
briefed ad
complain
nauseam
somewhere
at
else,
this
you
point.
idiot.
Their position that publicity is incompatible with a fair trial. The Algier case you mentioned, you know, I know that case. I litigated that case.
But
It
Karen,
involved a
is your name Karen in
confession
real life?
that the court found public because you have so many other tools to seat a fair and impartial jury. And we have cited that case repeatedly, and so has Your Honor, I think, recognized it
He
in
said
your
the
ruling,
same
saying
thing
pretrial
50
publicity
times
can
in this case
coexist
already, that
with
guy.
the defendant's right to a fair trial. So the last thing I'll say is just that the constitutional standard that I think we're all agreeing applies here is weighty and difficult to overcome. And it is never satisfied, as we've explained, by just generalized assertions that there's a lot of publicity out there. It's got to be something really specific, and they just haven't made that showing. And I certainly don't think that a video that apparently just shows the defendant walking around the UVU campus qualifies.
Thank you.
That's true.
Anything further?
He's going to rule in favor of the prosecution.
Judge, from the state, no, but I think I'd
No,
like to be
but.
crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets. I don't know if that makes a difference, Judge. I just wanted to make the record clear, and I want to be crystal clear with Your Honor.
Thank you, I appreciate that. Clarification, as it is
that
guiding for
causes
this
a
court
problem, maybe.
making its ruling. I turn to Utah, well, let
So
me
it has
pull
the
this
roof
up.
footage. God, I hope they play this.
So Rule 4-202.02. I go down to, well, first it says statement of the rule. 1, presumption of public court records. Court records are public unless otherwise classified
Thanks,
by this
Alex.
rule. 2, public court records include but are not limited to, and I'm going to go down to 2J, exhibits, but the judge may regulate or deny access to ensure the integrity of the exhibit, a fair trial, or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
Based off the representation of what is in that, the court differentiates this exhibit from the exhibits from yesterday, namely Exhibit 7, Exhibit 8, and Exhibit 9, as those are different in nature, and those go to issues relating to Utah Constitution, Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims. And the court also recognizes Utah Rule of Evidence 1102, as that is the foundation that's being laid for the admission of this exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media. We can proceed.
Thank you, Judge. Agent Hall, before we actually watch State's Exhibit 12.4, I have just a few questions. Yesterday, you testified at the very beginning of your investigation that you focused on the video that captured the shooter on the top of the low-C building. Is that correct?
Yes.
I believe you also testified that you began by working your way, and this is what I remember you saying, so correct me if I'm wrong, but you in essence testified that you began with that video and you started working your way backward and forward with the UVU surveillance video in an effort to trace the shooter's steps on campus. Is that right?
Correct.
Okay. Would you mind explaining just in a little bit more detail what you meant by that, tracking forward and backward on that video?
Yeah, we had a known when the shooting occurred, and as the officer testified, there was a video of an individual on the roof at the time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that bear fruit?
It did,
Did you
yes.
actually see from, at least in part, where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
Okay. You testified yesterday that in reference, I believe, to what's marked State's Exhibit 21, that you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same attempt, that is, to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess?
Yes, on each occasion, we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor. What you're going to see is a paused or a still image. And I'm going to ask if you recognize.
should put everything in there.
What, you see that now, Agent Hall?
I do, yes.
Okay.
Thanks,
Do
Tracy.
you recognize what's displayed on your monitor?
Yes, it's footage from the university that was provided to us, particularly of the parking structure.
Okay. Does it appear to be State's Exhibit 12.4?
It does, yes.
So I'm going to go ahead
Parking
and
structure,
I'm
just
going
like
to
I
have
said.
this video run. And then if you don't mind, as it's running, I'm probably going to be asking you some questions. And so this video has no audio, is that right?
No, there's no audio on the
Go
cameras.
to the monitor. Film it.
Let's go ahead and start the video.
Your Honor, it's just not up on the screen.
Dang.
Let's go ahead and put it on all screens.
So you see how it's at an angle? So
No,
you have
I
to widen
appreciate
it up later. It's so dumb.
It is, so it is admitted
Oh, look at that.
and
All right.
may be published to the screens. And.
Do not cut
just wanna
back
make
to the
sure
guys
it's on your
talking.
Screen, agent. All right. All right, Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately
8:29.
8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage.
Oh, look at that. He's got his
It's
maroon
the individual
shirt.
in the red T-shirt and the shorts.
No
and
backpack,
shoes.
though, right? Or does he have a backpack?
Do you believe you recognize who that person is?
Yep,
Yes.
no
Who
backpack.
is that?
I believe that's Tyler Robinson.
No, he does have a backpack. Really
All right, and where does he go from there?
little in it.
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I've previously referred it to.
All right. So he goes up onto campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
Probably more like that.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
That's crazy. Look at that. You can actually see him in the car in that one.
Now what do we see?
Ah, look at
This
this.
is Mr. Robinson returning to the campus on foot from the
I
neighborhood
know
to the
that. This
northeast.
is exactly my
You
dry
can see
run.
he's wearing the same
Can I get a
clothing as on the
boom?
previous video.
My dry
And
run.
he's carrying a blue backpack.
I told you they have
It's
him on
very
walking
clothing.
through the tunnel.
It's a maroon colored
Ah,
t-shirt.
look at that. I have that
with,
shot right there.
Gray or olive colored shorts.
Holy
and then
shit.
Converse shoes.
I've got this whole thing. I told you guys.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay.
I think right
And during
there.
this visit, do you know where he goes after he leaves the parking?
See, and that's that other
Yes,
camera. I
we
was
were able to
telling you.
track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then,
And
I'm sorry,
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
Hey, thanks, Porn
And from there, where does he go?
That's so crazy.
From there, he moves
This is
across
exactly-
campus, out across Campus Drive.
This is where he pulls his
into
phone
a
out,
wooded
right?
area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And
goes where?
then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
And from there?
From there, he comes
That's his dry
back
run.
down the stairs and walks off campus from that point.
That's the
And
dry run, you
About
guys.
what time was
I
that?
told you.
He left campus that
11?
second time? Do you know?
I believe it was approximately 11 a.m. or just after.
Ah,
if I recall.
boom.
I could verify from my
God
notes
damn,
if you need
man.
an exact
I
time.
should have ran the show here.
Yeah, if you don't mind.
The dry run, he left campus at 11.
That'll help you remember.
He had
refer
no
to it and read it
backpack,
out
but he
loud.
walked up onto the roof area. I told you
You know
guys.
you've had a chance to look at that, would you?
He did the dry run. God, that's amazing. See, man, logic, reason, common sense. Hey, thank you up there to Born to Raise Hogs and Stevie. That's so crazy. I mean, if you guys have been watching my channel, this is like, it's crazy.
Were you able to refresh your memory as far as the time?
I was, yes.
And what time was it?
It was just prior to 11 a.m. when he walked off campus.
Okay. And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I wonder what he did with that backpack, because he had it on at the beginning of the dry run.
I think it would be just to the north of the LDS Institute
Must
building,
have
if I
left it
recall.
somewhere.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay.
And I even said he probably left
All
around
right,
11. I mean, the same thing.
What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
Oh, you know, you could have seen him way
This
back
takes
here
just a moment.
on that grass coming in, interestingly. So here, then he gets his phone out.
And why, well, let me
I think
ask
he
you
stood there
this.
for like 3 or 4
You
minutes.
believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have are
No, I guess it was shorter. I wonder what he
from
did. He
my
must have
viewing
paused
and seeing
somewhere
Mr.
for a little
Robinson
bit.
on the video. It's the same person.
And like, here he goes. I told you they would have this shot
He's
where he comes through the
noticeably wearing
tunnel.
different clothing.
He is wearing different clothing.
And then this right here is
he
where they
also
took
is
that
walking
photo
with,
from, right there.
A gait or a limp
Right
in
there,
this
boom.
video.
They
With
cut
gait or
off
what?
part of it,
A
like
limp.
the top of it. Oh, see, that's where he killed time. He was doing something else. And then here he comes. See?
Now what do we see?
So it's
This
Mr.
is
Robinson coming up the stairs of the parking structure.
This is great.
Again, he seems to be having issues walking.
Thank you, Megan Kelly. For the people who watch this channel, this is all exactly what we thought it was going to be. And look at he struggles getting up the stairs. That's why when he goes on the campus. So we're going to start
Were you
seeing
able to
footage
track-
we haven't
so
seen
were
before.
you able
here
to
in a
track
minute.
Mr. Robinson when he leaves this parking structure?
Yes,
Oh,
we were able to.
He went walking straight.
So when he leaves the parking structure, where does he go?
He comes up around Campus Drive, as you can see on the
Oh,
video
yeah.
here.
Well, look at it.
There's
It's exactly what I have in my
There's
video.
a cut
guys.
through there
I can
north
see
of the
him.
Losi building, and that's Mr. Robinson.
He's right
coming up
there.
the
He's gonna
sidewalk.
walk right there
He
and
has
then-
the noticeable gait or limp in his walk. And then he moves south
I
across
did an animation of this. And look at he
front
walks
of the
right
Losi
on the
building.
sidewalk.
On the sidewalk?
Yes,
There's a
correct.
person with him there. Oh my God, that's crazy.
He would be the rear of the two individuals.
Yeah,
in this
see, he's this guy
particular
right
video.
there. It's really
So,
small.
so right now, if we were to break this picture into quadrants.
I have that in my
where
video.
Where would he be?
Who'd be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and
I
Mr.
told you you
Robinson
could
is
see.
appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations. that
God,
are on the video.
my video looks just like that too. I can see him over there. He's walking to the wall. He went a little bit further down.
And what time is this?
It's just afternoon,
This is
about 12:15
insane.
On what day?
on December.
Yep,
sorry,
and then
December,
he just
September
climbed over the
10th,
wall and he ducked
2025.
down, just how I have it in my
What just
animation.
happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the
I even
Losi
have him
building.
roll over the railing. Oh my God, man. This is crazy.
And again, in the top left corner, the individual is now seen running across the
Yeah,
rooftop
there he
of the
is.
Losi building
Right there.
to what would be the southwest corner of the building, crouching down and then crawling to the corner of the
Oh
building.
man, this is crazy.
And this is at what time?
Around 12:23.
See, unfortunately, they didn't get to be able to zoom in.
Timestamp on the video is 12:22
Maybe they can introduce
10th.
12.1 again.
on September 10th, yes,
So
2025.
we're clear, this is the roof of the Losi building.
Correct.
Yeah, this is
Can
unbelievable.
you still see that individual?
Yes, you can, laying prone.
Yeah, he's way over in that corner.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the...
Maybe he's just
reported
sightseeing, you
shot was
guys.
fired at
Did he have
12:28.
binoculars in the backpack?
individual
or-
then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. And they move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Anybody who's watched any of my recent
Do you see
videos,
Mr.
should
Robinson
see-
now?
Oh, the whole
I
time.
do, yes.
really.
He's just arriving at the corner of the building.
Yep, here he comes. This is one we've
Almost
already
the
seen.
top center of the image.
He jumps off the corner there.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Lofi
Now watch,
Losi
they're going to
building
show
onto
him
the
go
grass area,
across the street, and they'll
and
know
then
he went
moving
into the
away
woods.
towards Campus Drive.
And they're going to know he went into the woods. So you can see him running there. We've seen better
He appears
versions.
to be carrying some kind of an object in his hand at this time.
Right. And so this is right where I have my footage, right at the same location. And I think they'll pan it to the right
So
when he
he's
goes
approaching,
across the street.
Campus Drive.
and again, broken into quadrants. Where is he currently?
Be in the top right quadrant.
This video is almost over.
And the
but-
time?
It's 12:24 and 42 on the timestamp.
Oh, see, I told
What do
you,
we see
they
now?
pan to the right.
He then
Boom!
crosses Campus Drive.
God
and drops down
damn.
into the wooded area
This is
on
so
the
cool,
far
man.
side of Campus Drive.
And you'll see him go across, but you can't see him continue around.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
That's so crazy. Isn't that
What do
weird
we
to be able
see
to
now?
back engineer this shit?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive.
636.
That's the vehicle that's driven by Mr. Robinson.
And on the screen.
That's after Dairy
Where is
Queen.
that vehicle that you're referring to located, if you broke it into quadrants?
It's on the left side, on the upper side, the upper quadrant.
Now what do we see?
That vehicle's now pulling away and heading east on 800 South.
Probably saw that there were cop cars. And he didn't want to risk it.
And why do you believe that that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing
Now,
security
come on, you
detail.
guys. That's super
You know who
chat
that
worthy.
officer
there.
is?
Come on.
Or
Officer
was?
Goforth,
Okay, and do you know which department he works for?
Spanish Fork, please.
And did you have a conversation with Mr. Goforth regarding this interaction?
Here, I'm gonna show you
I
this
did, yes.
while he's talking.
And what time was that interaction? I'm sorry, did I ask you that?
It was approximately 12:30 a.m.
On the 11th?
on September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, or during, I guess during the early morning hours of the 11th?
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle, and then subsequently, when information was available that vehicle or a vehicle matching the description of that
See?
was involved in the incident,
This is so
he
crazy.
ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
See, I have him go into
information
the
he
parking
ran,
garage. Look at this.
Do
I
you know what
mean, it's just-
information, when you say that, he ran information?
there he is going
Yes, he ran a
back.
partial plate.
Okay. A license plate?
Correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes,
And did he tell you who the owner of that vehicle was?
he did, yes.
Okay, and who did he tell you that it belonged to?
Said there were two registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
Did he say
I thought he
anything about the
stood there
person that he
longer.
actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
See that? Look at that. Now watch this.
Let's return again to Wispin Stakes Exhibit 12.1.
That's exactly what he did right there. Look at this.
Again, you
in the
reviewed that
video.
video.
Yes.
Crazy.
And the difference between 12.1, or what's been marked as State's Exhibit 12.1,
He was
and
limping, of course.
12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
Yes.
So we make it to see
And
more.
specifically, be specific about the enhancements, and let's go one at a time.
Okay.
I think there's a reference to either red circles or red highlights.
exactly where it
Correct.
was.
That's how.
Hey,
Mr.
thank you
Olson
guys up
described
there,
red
Alec.
highlights.
We say
Yes.
how to
Do
hear.
you know what
apathetic
he's, or what is he referencing by the red highlights, or what do you believe
Look,
he's
he goes
referencing?
in.
I believe he's referring to red ovals or circles that were placed over the image to identify specific individuals of
And that's
note.
exactly what it looked like. He was over here more though.
And these red circles, are they permanent red circles? Are they temporary?
I'm
Different.
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
And that is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but
And he did this
I believe
exact
they
same thing
come
here.
off the video.
He ran across.
But
All right. And
And then I had to change it. I made it like this.
Well, and you said that the circles, what do the circles do?
they identify an area or a person of interest within the video.
And other than do that, do the circles or the highlights, do they do anything with regards to the video itself, as far as its accuracy?
Not to my knowledge, no.
Okay. I think the next enhancement that has been mentioned, that we've talked about, is there's some blurring.
Yes.
Crazy.
Do you know what that, tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage and their faces were blurred. Excuse me.
Is anything other than faces being blurred?
Not that I recall, no.
And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out part of the image, does it change or impact the accuracy?
It's so
in your
weird.
mind
This is just
of
like the Delphi
that part
case, you know,
of
where we
the
had
compilation video?
video
Not
that
to my
looked right
knowledge, no.
already.
And then the last thing is, I believe, is there's some zooming in and
Idaho
zooming out.
4,
It's in
same thing.
12.1 that has been removed
Yes.
from 12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop.
Mm-hmm.
I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Other than zooming in and zooming out, does at least that enhancement to the video, does it change the content of the video,
No,
the accuracy of the video in your mind?
no.
Okay.
No, that was really cool, being able to see that. And there's way
Is
more.
Are the enhancements in State's Exhibit, well, it's been marked as State's Exhibit 12.1, are they helpful in any way, or what do they add or take away from that video?
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the low-C rooftop, if I understand you correctly.
Yes.
Okay. And I think we've all watched that exhibit.
Correct.
4. And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
Okay. And the version that's in 12.1, does it facilitate at least that part of the video, seeing Mr. Robinson and tracking, I guess, his steps?
I believe so, yes.
Okay. Judge, at this point, I think in combination with yesterday, the foundation that was laid yesterday, including the written statement from Mr. Olson, which has been admitted into evidence and is, well, it's already been admitted into evidence. We believe there's enough foundation that at this point we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be well, beneficial for Your Honor to view it.
Ms. Nestor.
Oh, God.
Thank you, Your Honor. We renew our authenticity objection, and we also object to the, for admission purposes. And then we also object to
Same
the
thing.
publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other two. Again, Judge, we believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom.
Are they going to have
And it
the
should be published in such a way.
media
that
guy
you
come up
can have
again?
access to it.
All right. I do have a question in just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last 4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4
Well,
words,
I
unless
can
you
read,
want to share that
I
with
can
me.
read that. Or
Okay, go ahead and
needlessly
read that.
presenting cumulative evidence. So the court may, let me just read the whole rule for completeness. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the 2 videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video.
Yeah, I go back to
And unless
12.1.
you have very, very, very good vision, or you've zoomed in on that monitor,
That was fine.
you really can't see what Agent Hull has just described. The character of 12.1 is it simply, it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. and specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right, well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on the television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is I don't find it's necessary to replay this video, given the representation that's the exact same video, the difference being enhancements made. If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations.
They should have put that in the same video as I told you.
The interests of justice.
They should have the raw
requires it being
footage
played again.
and
But
the
it
edited
is
video
received
in
into
the same
evidence and
video.
will be reviewed by myself in determining a probable cause determination.
That's why these
And I
people don't know what they're
appreciate that, Judge.
doing.
And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received
I
into
always do
evidence,
it that
yes.
way.
And
Put the
your
raw
intent is
footage,
to review it
then zoom in.
its entirety, but not here in the courtroom.
Yes.
Can I make one suggestion, Judge, or maybe one request? I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that, if you want, we could isolate that and only play that portion of the video, if you'd be willing to publish that portion of the video. And that's really.
That's pretty cool that he
the
did.
thrust
He's
of
offering
why
this.
We are trying to introduce that
Come on.
exhibit, because
He doesn't have an out. The
we
judge doesn't have
believe
an
that
out
it's-
here.
It's helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did, but we had to memorialize it and save it.
Come on, accept it.
And then present it in that way, rather than just present it in its raw form and then have the ability to zoom in and out, if that helps Your Honor understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply.
Nestor doesn't want the zoomed in
the
portions.
Zooming in. How long is that, Mr. Sturgill?
I think it's a couple of minutes.
All right. Ms. Nestor?
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
Well, no, because it's
All
different.
right. Thank you. I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitor's counsel table and to the court's monitor on any portion that you wish to play for me to look at, so all parties can see clearly that the court is reviewing it in court. But I do not find that it is necessary for its publication, because this is the exact same video. I recognize it's zooming, but
See, they should have added it in the same original video.
And
Play the full video and then have it play
there is
again with
nothing
the
on this
zoomed in
video
portion.
from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary or.
Why?
And so
That's
in
ridiculous that he's
balancing the
saying that.
constitutional rights of all parties, I'll view it on the monitor. Counsel's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
Great, I appreciate that, Judge. I respect that. I think there's a natural break where we can start. And what I'm going to ask is just we simply play the You will have this entire exhibit in evidence, though.
Thank you.
Is that right?
That doesn't make sense.
All right, whenever you're ready. Counsel, as it relates to your monitors, just as a caution, if you don't want it to be wished to be picked up, and I'm not saying it will, I know there are camera operators being diligent in ensuring they're complying by the rules, but in abundance of caution, this is just your moment to take care of your screens if you feel the need to do so.
Sure, if I could just have one moment. Hold on, Kimberly.
Why is it such a big deal that you're
sure
zooming
where the
in
power button
to
is.
the judge and it's like, That's ridiculous. It's not playing the exact same thing. It's a version of the same thing
All right,
where it's
counsel for
easier
defense.
to make out
are
what
we
you're looking
prepared?
at,
And for the state.
especially with the
All
crappy
right. Thank you,
version that
having
we
heard
got
from
to
both
have.
counsel, I'll go ahead and review it on my screens. It is not being displayed in the monitor in the courtroom. And you may present 12.1, the portion you wish for me to view.
And the guy put the paper on top of the screen there, so we can't see it.
And just for the benefit of the record, do you want to put on the record the timestamp of what you're playing, at what point you're starting and stopping? As we go, or when we finish is fine. I just want the record to be complete.
Just the difficulty in doing that is because we've zoomed in, it's removed the timestamp on it. And so-
Well, you can just give me the
count
The
on the
count
video?
on the bottom. There's a timer at the bottom of the total length of the video, so that's fine. I'm just trying to create a record of what exactly I'm looking at.
Whenever we pause on the court system,
Oh, I see. No, it's limitations of technology sometimes. Thank you for letting me know.
So the count on the video is just before 6-minute mark, Judge.
All right.
And just so the record's clear, this is State's Exhibit 12.1.
Thank you. I have it on my screen. So it looks like it's been paused at 6 minutes and 9 seconds.
Agent Hall, can you see it?
Yes.
Okay, well, let's just, I'm good with playing it. And we'll play it. Go ahead, Kimberly.
It's playing.
right, and it's been paused, it looks like, at 6 minutes and 23 seconds.
I'm sorry. Judge, at 8:23, we stopped the video.
Oh, at 8:23, okay.
8:23.
See
That's the
small
count on
numbers.
the video itself.
Thank you.
Okay.
All right. Thank you, Mr. Sturgill.
Agent Hull, you were able to watch that zoomed-in version, is that
Yes, sir.
right? Okay, and was there anything that stood out watching that zoomed version?
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Okay. And you can see clear the clothing that he's wearing?
Object to leading.
Strike that.
Mr. Sturgill, do you want to respond to the
Yeah,
objection?
Judge, it is leading.
I'll go ahead and sustain the objection, and that you may move forward.
Is it easier to see? Well, strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Hall.
All right. Ms. Nestor.
Just one moment, Your Honor,
Of
if I may
course.
have the court's indulgence. Thank you. Do you want to take your?
And I was just going to suggest that. It seems like right now is a good time to take our morning break. It is 10:15. Let's come back at 10:30, and we'll resume with cross-examination of Agent Hull. Court is now in recess.
All right, well, there you go. I don't know. I kind of here's the problem. The prosecution seems like they're. I mean, the evidence is so overwhelming in this case that even if they're bumbling fools, it's gonna still work. The thing is the way they should have done that video was put the raw video on there, and then right after it, you play the same video that you want zoomed in on. You zoom in on. So like let's say he's walking in front of the Losi Center building. It's from a distance. And then you zoom in on the next one and you track him walking around. But it's right after that. So it's part of the video. So that means the raw and the edited version are in the same one. Then the judge wouldn't have to be able to claim, oh, well, you're just playing the same video again. Are you guys even here? Hello? I haven't seen a comment in 5 minutes, 2 minutes. Jesus, another one of these days, huh? God, just... Hello? Anybody here? Yeah. So they should have made a different version of the video. But also the judge, he's trying to seem like he's, trying to look out for the defense a little bit, he should have, I think he, in reality, should have played that. Okay. Yeah, well, if you're here, then type, you guys. I mean, it's not fun doing shows when you guys are just sitting there staring at the screen. It's just, it's just like type stuff in, have conversations about what we're listening to, et cetera, et cetera, et cetera. When you have these 2 minutes is a hell of a long time for no comments to happen. All right. And believe it or not, the small amount of comments that you're making affect YouTube sending people over to watch. Because when people are chatting and engaged, they go, ooh, look, people are over there. When you're just sitting there, sitting on your hands, I don't know. I've told you guys this 50,000 times, so I don't know. I can't make you guys type stuff in, but it's part of the reason why we struggle. Let's see. But wouldn't that risk him not showing it at all? No. Because once he So it wouldn't have risked him not showing it at all. You know, because he said, well, we need the raw version too. Well, there it is. The raw version's in there. That's all he cared about, was not that there wasn't a raw version of the same video. So they put out the raw version today, but what would have worked is if you played the raw, and then only the clips that you wanted to zoom in on, right after the raw version, you zoom in on the same thing. You go, okay, now we're going to play this again, but here's the zoomed in version. It would have been great. It's too late now, though. They can't do it. But at least we got to see what we got to see. Yeah, whatever. They can say whatever they want. It'll eventually all these videos will be released to the public. You know, maybe I would think though the versions that we're seeing, those should be released to the public later, right? Not just on the camera. Shouldn't they be released as a? I don't know. I guess might be after trial. They should have put them in the same video though. That would have worked. Because his argument the judge made yesterday was that you're only giving us the edited version of like him on the roof. The defense needs the whole video. So then they came back and put the whole video out there. And had they put the zoomed in version and the whole version in the same video, the judge would have he would have been trapped by his own logic and would have had to play it. No, I don't think it's going to set a precedence. But hey, you guys, could you guys please help support the channel today? As you can see, I'm pretty accurate. The stuff that we were just watching is exactly what I've been telling you for months and months. I've put it together. I've even made videos that look exactly like what we saw. So it'd be great to get the support from you guys. Channel memberships would be great.
Admitted and may be published to the screen.
All right, I'm gonna record this better. Does he keep zooming in? All right, right there.
And just want to make sure it's on your screen, Agent. All right. Just want to make sure it's on your screen, Agent. All right. All right. Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information.
Their vehicle belongs to Mr. Robinson.
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes.
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I've previously referred it to.
All right. So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video.
The dry run.
And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then, I'm sorry,
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
From there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Just let me know when you've had a chance to look at that, would you? Were you able to refresh your memory as far as the time?
I was, yes.
Okay, and what time was it?
It was just prior to 11 a.m. when he walked off campus.
Okay. And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment. And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay.
See if we can see that bulge when he goes up.
Now what do we see?
So this is Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
And again, were you able to track,
This is
track
crazy.
Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive. As you can see on the video here, there is a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
He would be the rear of the two individuals in this particular video.
All right. So right now, if you were to break this picture into quadrants, where would he be?
Who'd be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
Okay. And what time is this?
It's just afternoon, about 12:15
On what day?
on September 10th, 2025.
Okay. What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right. Go ahead, sir.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building.
He actually shoots in 1 minute.
Crouching down and
from
then
right
crawling
now.
to the corner of the building.
Less than a minute from now, he's already shot Charlie Kirk. Isn't that crazy?
And this is at what time?
Around 12:23. I think the timestamp on the video is 12:22.
On the 10th.
On September 10th, yes.
They always leave out
2025.
So we're
seconds
clear,
for
this
some
is the
reason.
roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
We can see what time he stands up. We'll see what it should be around 12:23, 27, or 8. So let's see.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. Individual then stands up and then moves across the building.
See, I nailed that too.
So
I got
we're
it
seeing happening
12:23,
right now.
28, just like you
It is,
said.
yes. They
Can
move
I get a
behind
boom?
The atrium area on the rooftop.
That's exactly the
the
time that
northeast
I
corner where
had
the
in the
white
document.
triangle is.
12:23, 28.
Do you see Mr. Robinson
I missed that the
now?
first time around.
I do, yes. He's just arriving at the corner of the building,
That's crazy.
almost the top center of the image.
Hey, thanks, Phyllis. Yeah, very insightful conclusion you
now?
came to with
And
the
Mr.
scan
Robinson
info we
lowering
were
and
given.
jumping off of the
Almost
roof
like
of
you
the
were
roof
there.
of
Oh my
building
God, they're
onto the
going
grass
to call
area,
me a conspiracy theory.
and then moving away towards Campus Drive.
Perfectly sound reasoning and immaculate
He
representation.
appears to be carrying
Well,
some
thank
kind
you.
of an object in his hand at this time.
That is so crazy. I used Bartholomew's video and got 12:23, 28. And that's exactly the time on this video he stood
So
up.
he's approaching,
Campus Drive.
and again,
he said
broken
that
into
on the
quadrants.
video.
Where is he currently?
Be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
And on the screen, where is that vehicle that you're referring to located, if you broke it into quadrants?
It's on the left side, on the upper side, the upper quadrant.
I know, I got to keep recording this, even if they're back from recess.
Now what do we see?
It's just Nestor asking.
That vehicle's now pulling away and heading east on 800 South.
And why do you believe that vehicle is Mr. Robinson's vehicle?
Okay.
When that vehicle was stopped, it actually
That
made
was
contact with an officer who was doing.
Doesn't look like it. So let me see. Yeah, I guess here it is right here.
We'll go ahead and pick up where we left off. I note that the parties for each side are present in the courtroom, and we're picking up with cross-examination of Agent Hull. Ms. Nestor, your witness.
May it please the court, thank you. Good afternoon, Agent Hall.
Good
You
morning.
and I have met before, but just to remind you, my name's Kathy Nestor. I'm one of the attorneys representing Mr. Robinson. So, when did you leave the SBI?
The State Bureau of Investigation?
Yes,
March of this year.
March of this year?
And why is that,
So
sir?
you were involved in this investigation from September to March, basically.
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate potential wrongdoing of police officers?
Correct.
Okay. So when you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBI on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
I know the screen's dark.
Approximately an hour after Mr. Kirk had already been removed from the...
Approximately, yes.
Okay. And were you involved in putting up any drones into the air? Were you part of that, or were you not
It's
involved in
not,
that?
no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge?
For the first 2 hours, I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area?
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process?
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured and also an area off of the side of that building that had been secured by an officer.
And that building was the Losi building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th, yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet, and now you're saying it was a
That's correct.
cartridge?
When a weapon is cleared,
Uh-huh.
an officer would make his rifle ready, which would chamber around.
Oh, I got you.
My understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
Okay. Do you know where that bullet is now?
I don't.
Okay. So you had the amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent or what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter.
The person I believe to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were they were all ultimately cleared by you or somebody connected with you?
Correct.
And were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun.
Any other guns that were found on the scene?
Not that I recall.
Do you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster? Does that refresh your memory?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay. And just a moment, Your Honor. And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay. Can we pull up? Exhibit Hole 13 and just show it only to the witness for right now? All right, can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by, actually, Mr. Davis, who's going to testify later in this matter, is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez, is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day?
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Uh-oh.
Trooper Gonzalez included in his report that there was a gun, yes.
Okay. Thank you. Okay. When did you first personally go up to the roof of the Losi building? Do you remember the time of that?
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
And at the time you went up there was already crime scene tape that had been placed around it?
There was an officer standing security.
Right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the Losi roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the Losi building?
When you say around the Losi building, you mean how close? Like immediately around the Losi building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline, is that right?
Correct.
And can you pull up hole 1, please? I'm pulling up on your screen your report that you prepared. Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
It looks like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
So, as of September 14th, Tyler Robinson had already turned himself in to the authorities, is that right?
Yes, I believe he turned himself in on September 11th.
So, prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was, is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay. And you became aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation,
Okay.
or the second evening of the investigation.
All right, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof?
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that, is that right?
Excuse me. Determine who he was or
No.
determine distinguishing features?
Determine distinguishing features of the video
Yeah.
of the person on the roof.
Yes, we had a person of interest and those images were released to the press.
You're talking about the ones in the stairwell from the...
Correct,
From the parking garage.
correct.
But the video on the roof was not distinguishable, fair?
That video as a standalone
Yes,
was not, no.
okay. And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
Sorry, I'm not sure I understand the question.
Did you, at some point in your investigation, collect from two young men who were present at the event a video that they had taken of someone on the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video
And ultimately, some screenshots were taken out of that video, is that right?
by,
By you?
not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did you see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event,
Okay.
if that's my recollection.
And do you remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay. There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct?
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Correct?
And is this the moment where you are submitting that he was holding a gun in his hand?
As he crossed the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual
In
gun?
the video?
Yeah,
No.
all right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay. Also, when you were revealing the timeline, exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was, my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
I think you asked how long he was prone. I
Right.
think it took longer for him to crawl into position
Okay,
and then establish a position
Oh.
and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
okay, thank you. All right. I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so that in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct?
And it showed like a dead-on view of Mr. Kirk and his, parts of his security team, is that right? And then you also have video that you described that shows the back of the tent at the moment the shot happened, is that right? Behind Mr.
Are
Kirk?
you referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay, and can we pull up the last video, the last clip, 49? I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct.
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Losi building. Is that fair?
I can't answer that question.
Yeah, sure.
And Ms. Nestor, as you're playing this, are you just being cognizant if the sound is on or not?
I don't want the sound. Please.
Okay, I just wanted
not
to
have- Thank you for bringing
clarify.
that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be displayed on the main monitor. Ms. Nestor, you may proceed.
Thank you. Is it playing? Okay. Do you remember that? Does that refresh your memory of what's in that clip?
Yes.
And having reviewed that, at the time the shot was fired, there was no one standing directly behind the tent. Is that correct?
You'd have to show me it again. I wasn't specifically looking for that.
Okay,
But I can answer that question if I can view the video again.
okay. And just before you do that, I think you testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Approximately.
Okay, so what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
So there's a videographer on the right side of the tent, and then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right?
Yes, behind the tent.
Correct. But directly in the middle of the tent, is there anyone standing?
There's no one stood in the middle behind the tent, no.
Thank you. All right, I want to talk now about the TP. You can take it down off of the screen. Thank you. I want to talk now about the TPUSA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience during when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you. All right. Were you involved when the gun was located in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value. and then it was secured, and then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I
analyzed?
was not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report, no, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
It would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay. So you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
Okay. You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence, yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my head.
Do you know how many fragments from the bullets?
I don't.
Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Ms. Noble? Yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Ms. Noble at that time.
Okay. Can we please bring up whole... Sorry, just a moment. Let's see. Poll 48. This is Ms. Noble's interview. Do you have it?
Thank you,
All right,
Mama,
do you
for
remember
copy,
that?
and
Looking at
welcome,
that
CJ.
interview, does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that Ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car?
Yes, I believe they thought that was the case.
Okay. I want to go back, if I can, to the scene itself, the preservation of the actual scene where Mr. Kirk passed. Did you all have canine dogs at any point that sniffed that area?
I don't know specifically that area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
This
My
is all
understanding
Candace
is that it
Owens
may
shit
have been
right here.
used in an
All
effort
of
to
this.
track an individual that had jumped off the
It's
roof.
so stupid.
but
They watch your show.
I don't know for
Ooh,
certain.
good point. Let me try that
And
one.
obviously, that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay. Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent?
Me, personally?
Right.
No.
So you're not sure when it was removed?
No.
And were you involved in the decision to pave over the dirt that was under the tent?
At UVU?
Uh-huh.
No.
Did you know that happened?
Only because it was in the news.
All right.
See?
But you don't know when.
The paved
or
over
who
dirt
ordered
shit.
that.
They came out of those tunnels. This is so stupid. This is embarrassing for the defense here. Embarrassing.
And it's true that during the time before Mr. Robinson turned himself in, you all received
That's all. That's a
lots and
nod to
lots of
Candace
tips from
Owens
the
and her
public. Is that
ravenous
fair?
followers.
You received tips. of
She's
death
on it,
threats
man.
that Mr.
She's on
Kirk
it.
Had received before, the day before the shooting. Is that right?
That's sick.
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify. That
Thank
was
you.
a confusing question. As you were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay, and a lot of those, some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our
is
state
ridiculous.
information and analysis center
embarrassing
that had been
herself.
set up.
Except it's
And you
giving a
also
nod
got
to
multiple
Candace
tips
and her
about
followers. That's
potential
it.
suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
But it was when the parents who called,
And then Mr. Robinson turned himself in.
who said that's our kid.
Right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I didn't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was
Yeah,
the first
fixed
time that we
the
had a
aspect
name of an
ratio.
individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in terms of what you've described. I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
Thank you, Agent Hall. I tender the witness, Your Honor.
Thank you. Redirect by the state.
See, there's a much clearer version of this, obviously. He's still limping.
I'm just going to go back to a few things that Ms. Nestor asked you about. First of all, the unfired bullet that you referred to. It's your understanding that that bullet was accounted for?
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have maybe been clearing his weapon.
Yes, that's what I recall being told about that particular item, yes.
All Are you aware of, if on the 10th, there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, there was,
So he goes to the corner there.
it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. So there was a large, rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay.
He goes right
And
there.
what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently, specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they
I
carrying?
believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
Okay. When you said that it was possible that that round was from an officer clearing his weapon, what exactly do you mean by that?
Our standard practice in our department is to carry a rifle cruiser ready, which
I'm
is
sorry?
we carry our rifles in a situation which is called cruiser ready.
What does that mean?
It means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
Okay. And you're aware of, is that something that's common among police officers in this situation?
I believe for most agencies, that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear the campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars, so I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
Now I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you remember that question?
Yes, I think I was asked whether he had a gun in, or I had seen a gun in his hand in the video.
And you said that you did see something in his hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point, after Mr. Robinson stood up on top of the Losi building and ran across, I believe to the northeast corner, when did you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
Okay, and that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
Okay. And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position, and then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Okay. Can you be more specific or describe in more detail?
It appears to be black, and it appears to be longer.
Okay, anything else about that item?
No.
Okay. I believe it was Exhibit 9, State's Exhibit 9, that Ms. Nestor pulled up on the screen, and she had you look at that. And I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video, is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind, where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner.
Sure.
In that tunnel view.
Yes.
And on the other side of that banner is the tent and then the rest of the courtyard. Is that fair to
Correct.
say? Do you remember seeing the banner
Yes.
in the video? Okay, and.
You're referring to the back of the pop-up tent?
Correct, yes.
Okay, yes.
Okay. And do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent? How would
No, you
describe
can't see through it. It's white,
Right.
and you cannot see through it, no.
it? And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see. You would not be able to see through it. You would not be able to see through it from the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Okay. Well, we exhibited, or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at, is that right?
Correct.
Okay. And leading up, and again, I'm referring to that view, that tunnel view of that surveillance camera, leading up to the shot, what's going on behind that banner?
There are representatives, I believe, of TPUSA, but there are representatives of TPUSA, there are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Okay. Directly behind the banner?
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been, between today and yesterday, that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of the?
They appeared to be the same.
You're aware that a rifle was eventually discovered?
Yes.
And was it your understanding that that rifle was discovered in a wooded area?
It was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
Well, that was a good reply there.
And that rifle was discovered on the 10th?
Yes.
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event?
Yes.
And did you follow up on those tips?
After tips had been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
Okay. So managed by law enforcement, so.
Correct.
Did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people reporting to police that they felt like they knew who the shooter was.
Yes.
Okay. So identities of possible shooters.
Correct.
Did law enforcement follow up on those tips as well?
They did.
Ms. Nestor, finally, Ms. Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes.
Okay. And that was the Washington County Sheriff's Office.
Yes.
Okay. You understood that he turned him. Well, he showed up there voluntarily. Is that right?
Correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Okay. Nothing further. Oh, sorry.
That guy put some good stuff out there at the end.
In the video that we've already talked about, the video where Mr. Robinson stands up and runs across the top of the Losi building, is there, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position.
Correct.
And then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May Agent Hull be excused?
Yes, Your Honor.
All right, Agent Hull, thank you.
Thank you, Your Honor.
Can we have just a minute to meet if, okay.
All right, let's take a 5-minute break and allowing parties to confer. Court is in a brief recess.
All right. Well, that was good stuff by him at the end there. Oh yeah, the rifle was found in the woods that this attorney isn't very good though, whoever this guy is. I hope he's not the one. But you guys, I need your guys' support when I do these shows. It's hard to justify sitting here for 8 hours. I don't get any ad revenue. The video at the end of the day, because it's Charlie Kirk being shot, they say, oh, yep, not monetizable. All right. So the only income is from you guys that are watching the show. So if you feel like I do a good job and I put out the good information, I would appreciate your support. You know, it sucks that I have to say it so many times, but I don't know what else to tell you. I can't sit here for 8.5 hours while it's just, I could be doing something else, working on a video or doing something, trying to do something. All right, so we're sitting here streaming. So if you guys have the ability to gift some channel memberships to people or super chats or whatever, that would be great. We're currently we're already almost 3 hours in, and we're not even at what on a normal night would be halfway to the goal. All right. So is there any chance you guys could help support the channel during the show? It makes it a lot more sort of energetic for me, instead of just sitting there staring at the screen. Yeah. And doesn't seem like anybody heard me. Hey, thanks, Phyllis Watson. I mean, it's weird. It's like that for every channel. But, if a channel has 4,000 people watching, they don't have to worry about it. And I don't know what it is because YouTube will monetize their live stream. But when you have 200 people, they don't really do it. So I don't know what the deal is there. But it is what it is. So I need your guys' support. I think they were appointed, but they picked really experienced ones. And they probably wanted to do it. No, there should be, but I don't get that many people, so I need your guys' support, okay? We had Phyllis Watson there. But, man, you guys, it's, just think of myself as a Snickers bar. They're like $2.50. Frustrating just sitting there for a whole hour looking at the screen and there isn't one super chat or anything. It's like, what happened to the old freaks that used to be around, you know? It's crazy. All right. I'm just trying to, I don't know, I'm trying to upload this video. Why does it say that? Up to 24 hours. What the hell are you talking about? Thank you, AOCTW. Yeah, and say the thing is, Dig, nobody wants to hear your response. What I'm telling you is I always tell people, if you can't afford it, don't do it. So we don't need to hear that you're broke, okay? Yeah, it's just kind of one of those, it's like a troll kind of comment. It's weird. All right, so we got, hey, thanks, Grinch and AOCTW. And it's just one of those people that wants everybody to know why. Nobody's told you to send in a nickel. I'm asking the people and saying, hey, you know, I need your guys' support, the ones that can, okay? Because, you know, it's hard to sit for 8 hours just staring at a screen. And if you were doing what I'm doing, you'd do the same thing. You'd say the same thing in the same position. It's very frustrating. Thank you, Roger Smith. And the thing is if you go through this case, I've covered it better, more accurately than any other person covering the case. And for some reason, they're watching somewhere else. You know, it's like, oh, I gotta go watch the ones where I can be a conspiratorial nut job. You know, it's just crazy. Doesn't make any sense. Yeah, so I don't really know what to tell you. But we don't need the people that go, well, I can't because, well, nobody asked you that, though. The thing is I'm saying, if you're out there, and how many times have I said this sentence? If you're out there and you have the ability to help support the channel, I would appreciate it. I've said that literally 1,000 times on the channel. I don't know what to say. But I'm trying to make it worth my while to do these 8-hour live streams. And it also, at the end of the month, my channel, unlike every other one that you guys watch out there, donates thousands of dollars to true crime-related charities. And we have our own scholarship fund, and we have our own DNA fund for identifying Jane and John Does. And because of all of you guys and ad revenue when it happens over the years, we've donated over $300,000 to true crime-related charities. We just hit that 300,000 mark at the end of last month. And if that doesn't mean anything, then it doesn't mean anything to you. Okay? But I'm just trying to tell you from my position, it's very difficult. I got out of the algorithm for some reason in this case because I didn't keep talking about it every single day. You know? And then you switch over to another case. And then as soon as you switch off of that one, you're not in the you literally have to cover a case forever, every single day, over and over and over and over and over again to get even put back slightly into an algorithm. I mean, it really is ridiculous. We cover cold cases sometimes, etc. Hey, thanks, Christy Roberts. Thank you for the detailed coverage. I've been watching since Delphi. Hey, cool. And by the way, the Delphi case, I did the same thing. Do you guys know that in the Delphi case, that I think within 8 days of less than that, of the murders, like literally way before, like I think 7 days after, I developed the flow of the crime, where the kids were walking, where they were made to go down, where they crossed the creek, and where they were found, and I put it all together, and the prosecutor actually got a hold of me and said, hey, well, we really like what you made there. If we make an arrest soon, we can probably give you other information to even make it more accurate. So if you could, and that's what he talked to me about. But they didn't make an arrest for 5 years, and that prosecutor left. And and then I made an animation, literally like months into it, and the animation, after everybody had seen the animation 1,000,000 times. When we saw the real video come out, it was like, we've seen this 1,000 times. We already saw it. It's crazy. Because I made an animation right at the end of the bridge, walking across, and it went down exactly like that. And then in the Idaho 4 case, I put all of the pieces together. It wasn't, sometimes it was like what direction the car went after it left. We didn't have that, but we had this little loop action. And all of that information put together, we nailed it here, okay? But people seem to want to watch the conspiratorial nutjobs who cover cases. It's crazy. This case right here, the Tyler Robinson case, is probably the most straightforward, strongest case I've ever seen in the history of me covering true crime. I mean, literally, I've been doing true crime for 13 years. On YouTube. So it's just, there isn't one even close to this one. This one is a slam dunk. Okay? It's just absolutely unbelievable. And it's crazy to me that there's lunatics out there that they're like, I'm not sure, man. I'm not sure. This is weird. That something just doesn't add up. You know what doesn't add up? Your brain. When you were born, your brain didn't add up. Now, the only way that this will be a hung jury or something is if, because of nutjobs like Candace Owens selling the BS to so many people, they get a stealth juror on there. This lady right here, this Nestor idiot, she's literally out there saying the exact same stuff that Candace Owens says because she knows that'll add traction and hype and interest in that huge audience that the dipshit Candace Owens has, okay? And that's exactly what she is. I think she is actually a stupid person who can speak. That's the reality of it. She is one of those, just an absolutely ignorant fool of an idiot who can actually speak. All right? And she's articulate, like, oh man, and can argue back and forth quickly, and she's sharp. But the only way that you can believe the things, you either have to believe this, that she's an absolute idiot or a conniving, sick, greedy bastard who's only doing it to get the thousands and thousands of views she gets. She's made millions, you guys, since Charlie Kirk was shot on this case. Literally. I know it. I can tell you, she has videos that have 1 million views. Those all made her $15,000. And those are like on a day, right? So then she's done it every single day, 5 days a week, so like $100,000 a week she's making, $400,000 a month. I mean, it's ridiculous. And then look at all that. And then I'm over here working my ass off, putting together meticulously the information where it's real. If you watch those animations that I just made recently and compare it to what they just showed you in court right now today, you'd go, holy shit, Gray showed us the same damn thing in that animation just even 2 months ago. But I've been talking about it the whole time. See, that's what I'm trying to tell you guys. It's like, how come a channel like this, when I'm and here's the thing, if I had 500, 600, 700 people, I wouldn't have to ever ask, hey, you guys, can you please help support the channel? Because just by the sheer numbers of people, there's people that do that. And that's what sucks, is I can't get those people because nobody wants to hear the reality. It's more entertaining to do the crazy conspiracy theories. It just sucks, you guys. I mean, honest to God. Oh, okay, it looks like it worked. Okay, so let's see. I'm just going to post this thing. All right, so I just posted the video. I didn't put any ending or beginning or anything. It's just the raw surveillance footage. I made it, put it out on a video. Okay. Let's see how that does. I bet nobody watches the damn thing. Even though I fixed the aspect ratio, I fixed the skewed part because of the angle they're shooting at. The right side's more, it goes down at the top and then up at the bottom. And so you have to pull the right and, the right top and the right bottom up. And then you have to widen it out to match the screen. And then, okay, now it's not this narrow looking weird video. All right, and so we can watch it right here while we're on the break. See, look how much better this looks. That's what it's supposed to look like. See, he doesn't look the way they, this, for example, let me just go like around in here when he's walking through the tunnel. And see, isn't this amazing too? Like, look at this, 10:09:42. And so it's probably that. Let me pull up the video, this one right here, I think. Yeah, watch this. So the dry run is over here. I have the dry run. This is in the morning when he was at that parking garage. And look at this. I literally have, let me go to this part right here. Right there. This is the Dodge Challenger driving down the road, right? Now watch this. It's going to turn. I'll just speed it up a little bit to there. And here it comes. And that's where they had it on camera stopping here. It wanted to go there, but then it went straight on that in the evening. It's 6:36, I think it was. So look at this. Here it is. Here's the Dodge Challenger. And it goes right into this parking garage. Right here. See that? That's where he went in. So look, it goes in, and then watch this. I could go right there, and then I could switch over to this, and then go like this. And here it comes. It's going to come into the, well, I think they talk for a little bit, but there it is right there. It comes in right as, like I could literally cut the video to right there, and here it comes into the parking garage. Remember how I had it just going in there? And there it is. See? There it goes into the parking garage. And then, so this is at 9 or 8 something in the morning at this point. Let's see, does it have the time? It's so dark up there. I mean, light, you can't see it. So this is early in the morning, and then he ends up leaving a little while later. There he goes. So that's at 9:30 something in the morning. Right here, right there. So when that car leaves, I'm just kind of scrubbing forward. And then here this one is. So look at the time on this one. It's 10:09 and 23 seconds. Okay, but now we go back to my video that I made a long time ago. And we're going to go I have the same order they're doing it. It's crazy. I mean, it's crazy. Look at this. But I started here. See, here's 9:57. Here's Tyler Robinson. Look at that. That's exactly what he was wearing in that video we just saw, right? He's just got the same damn stuff on. Now here he goes. He's walking, and I went to this house and got this video. He walks all the way around over there. Okay, and then a little bit later, after he walks all around the neighborhood, this is from a 360-degree camera, he walks down, and then right here, we see him again. And remember how Candace Owens said this was 8:07? I determined by using shadow analysis that this was 10:07. Yeah, 10:08 is what I have. Okay, I'm just using shadows, so you can be off by a minute or so. So it might be 10:07. I have it like 10:08 just because of how long it took me to walk. But look at, even 10:08 works. So 10:08 there, and then we go over to this, and look at this, 10:09 and 23 seconds. And all he was doing from there is let me show you. So he was walking right here in that video. He walks right there at 10:08, and I had like 2 seconds. He goes like this, across, and then right here it's 10:09 and 30-something seconds going into the tunnel. See, I absolutely nailed that. Okay, I'm the one that told everybody that there was a dry run at 10:08. I wonder if people will give credit to that today. I guarantee you not. They'll go, oh, yeah, I thought of that. Yeah, I thought of that. Yeah. Right, so I put together that whole sequence there, onto campus, and you know what I said? I go, yeah, I think he left at around 11. You know, he goes to campus, leaves at 11, gets back to his car, and guess what? That's what they said today. They left at 11. Also verified today was the shot time. I got Andrew Bartholomew's video, and I had him keep researching until he could find me the actual time that the video started to the second. So he gave me that. And then I took his video and I back engineered it all the way through, coming up with, on here it says 12:23:29, but it's 12:23:28 and something. That's what I came up with.
Hall was excused, and we are proceeding.
Anyways,
Mr. McBride.
there you go. So even the gunshot time I got right. I was the first person to put that out there.
Yes, Your Honor.
But it doesn't matter to people.
We intend to call
They'd rather watch
Jennifer
the
Falmolina.
bullshit
Before I do that,
conspiracy theorists.
I'd move the admission of State's Exhibit 5.1, if I can approach the bench.
Hey, thanks,
Yes.
DR.
Thank you.
Anyways, I'm just saying, you know, I'm frustrated as hell.
There'll
You know,
be
that's all I can
an
tell you.
objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
All right. Let me just, do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Englehart from Turning Point USA.
All right.
And yeah, again, I say it's a self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. McBride. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance. There are sub-issues. There's also a problem under 1102, because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person, so it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection, because the court said no speaking objections? Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections.
Thanks,
I'm
Alec.
prepared to keep going in open court.
Phyllis Watson.
What the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak.
Thanks, Jeannie, up
you're,
there.
And again, I appreciate your discretion and
To girl, thank you.
highlighting that point.
Or T-girl.
Do you anticipate your
Anne-Marie.
argument being of the nature that would
McCartney.
would
Christie,
defeat the purpose of
Roger,
if the court
Egrinch,
does not admit this, that
AOC,
you've already let the cat out of the bag with your argument, or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see I mean, I do think, I am not trying to conceal from anybody in the courtroom or the public our concerns about relevance, so why don't I, taking the court's lead, go forward publicly with my concerns about relevance, and if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then, what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the 3rd person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3, paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the 2nd paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is, and I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence, and there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Engelhardt's beliefs. What he says were Mr. Kirk's beliefs. What Mr. Engelhardt says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Engelhardt's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence.
Thanks,
but
Beaver.
it's Mr. Engelhardt's opinions
Or Bev
about
something.
a branch of Christianity.
Bev
His
Crabtree.
opinions about a portion of the Bible. He quotes the Bible, and he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah Code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
Thank you. And as the court knows, but I want the record to be clear, when I refer to the, what the information calls the victim targeting enhancement, that's Utah Code Section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges, and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about? Or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here? The latter is the state invoking Mr. Kirk's political expression, and now I'm quoting the statute, as the personal attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging, I should say, there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K. The 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head if anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant. And that's why we think it should not be received into evidence. There's a second level here, which is Mr. Engelhardt's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical question. If the state asked the court to take judicial notice of a portion of the Bible in order to prove this enhancement, because I can't see where else it fits into this case, I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here, in this proceeding, what the book of Matthew says. It doesn't matter what Mr. Engelhardt thinks, and again, I say this with all due respect to Mr. Engelhardt, who I've never met, the book of Matthew means, or how one reconciles the book of Matthew as he sees it with other views on the topics that are there. I mean, I want to be careful and not suggest what other views are, because I shouldn't be testifying about different perspectives within the sort of the heading of religion. But it doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. That's your honor. There is nothing in this that helps the court resolve, with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court, because the court has to decide whether there is evidence of the target enhancement in the way I think I've structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly, and one of which I think is appropriately discussed at sidebar, because it does get into undue prejudice. The 403 here is that receiving this document into evidence is going to create confusion. It's going to create chaos, not by the trier of fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Engelhardt's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are in any way what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Englehart's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here. And when I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a, sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Englehart for some specific evidentiary purpose that I'm missing, then we can engage in that. But it seems to me that it's, again, a mixture of lay and expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak. Turning to the state. And so just to give an overview, what I'm intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you. Mr. McBride.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence, persuasive evidence. And 2, it is relevant to the victim targeting enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the exhibit which we are discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading from the actual 1102, because it's not admitted into evidence, I will, well, before I do that, let me turn to you about the objection to make sure that you are heard as well.
Yes, Rule 104 requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit? That's what I'm putting in front of Your Honor, is explaining this is why the exhibit is admissible, because it contains this language that is relevant and probative. I don't know how I can make an argument something's relevant and probative without saying this is what the exhibit says.
Well, Mr. Novak, and I want to make sure I do see you have a microphone. Go ahead.
Oh.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. Okay. I understand that the court has two roles, one under 104 and one as the magistrate. But that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to confuse the issues in this case and create fair trial risks for Mr. Robinson.
All right. Thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding. But I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and to their right to fairness, requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at this, typically in court, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19, and talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly, saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to constrain you from saying, well, I don't know what you're going to say, but
Yeah.
I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained to Mr. McBride in regards to your response, the rebuttal to the argument by Mr. Novak. What is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, after the court rules on that, I will make my full argument.
All right, well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty, I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully, be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing it. I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without quoting it verbatim in open court.
No, I don't think so.
All right.
Your Honor, if you're going to make a closure ruling, I'd like to be heard before you do.
All right, I'll hear from you as well. If you would like to come forward, again, just, Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure, thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kern's Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kern's Tribune also speaks to this. And that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kearns Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, a closed session or a sidebar, or however, you have also done it in chambers, I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, it appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits, that was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment, it's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or at what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
All right, thank you. Anything further, Mr. McBride?
Just to note, I have not made my full argument on admissibility, that's all.
All right. All right, I appreciate the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder, and whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information going to the very beginning, whether this is relevant. And as noted by counsel, looking to count 1, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything. But what is before this court under count 1, aggravated murder, which is a capital offense, victim targeting enhancement, in violation of Utah Code Annotated 76-3-203.14, sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression. And so, if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds, but at this point, the court finds it is relevant for consideration, and for the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3. That these events discussed political issues as well as religious issues. Those political issues in the portion I previously quoted talked about gender issues in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses. It talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity. For that reason, Your Honor, this exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder. Whether or not it has, some capability of prejudicing the potential jury pool, I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here, but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views, that's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that, and that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually, the state doesn't have to establish motive. Motive is not an element of the offense. But at least with respect to the victim enhancement, according to the legislature, the question is, what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit. So what we have in this document are what I think are purport to be untested expert opinions or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document that Mr. Robinson had disagreement with Mr. Kirk's political expression? None of that appears in this document. There may be other evidence of that we'll have to see, but there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind because he doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious doctrine and that involves Mr. Engelhardt's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks Chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court concluding what Mr. Kirk thought Chapter 19 of Matthew means? So
This guy's
it's
an
not
idiot.
relevant.
He's stupid. It
It's
is
improper
relevant. You're
opinion
lying,
evidence.
You're dumb. You're stupid.
It's definitely overbroad in terms of the evidence that the state is proffering to prove a very narrow point, and it actually doesn't get to that point, which is what was Mr. Robinson's state of mind.
This guy is eating up
It also
lunch.
doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard.
This
Or
guy
anything
is
that Mr.
really
Kirk
out
said
to lunch.
before September 10th, specifically. that Mr. Robinson may or
What
may
else?
not.
Come on, what else we got?
Nor
Come on,
has
who's
the
got one?
state presented any evidence, and as an officer of the court, I would say, I don't think the state can present any evidence.
I'm hangry. Here's a
that
Snickers bar.
Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will
This
say
guy's
are
gonna eat up
admissions
your
by
lunch.
Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue.
I love Snickers. That's my favorite. That's
That
like
would
go-to
even make
candy
a
bar.
piece of
That's why I
this
always say, get me a Snickers.
relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself.
Yeah,
So I'm
well,
just gonna
you've been
stop
doing that
Unless
quite
the
a
court
bit.
has questions.
I don't. Thank you. Well, I do have a question as it relates to
Hey, what planet do you live on, sir?
political expressions. Does religion or gender intersect with political expressions?
Yeah.
I think that's a great question, but probably not a question
That you want to answer
to be
because it doesn't help your
answered
client.
by me in this proceeding.
Right, right. 'Cause
That's actually a really, really complicated question.
yeah, because gender
that the
identity is
state
political.
Wants the court to say is a simple yes.
Not really great. That's just who they identify. Shut the hell up, man. Give me a break.
All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify.
I've eaten those ice cream bars. Those are
I'm not
good.
trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is
Hey,
whether
he's trying to butter up the judge.
The way it's presented.
Hey,
the
Judge,
way
I'm
it
letting
was
you know, I
written
think you're really smart, man. You are fantastic. Great. With all due
is
respect, you are.
admissible
Man, what a great,
under
what a great
relevance
question.
and expert.
Did I tell you it was a great question
701,
already?
702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to
He did.
Mr.
His
Kirk's
parents
political
said that.
expression.
His parents had arguments with him about
And I don't
things.
think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because
Which
you mentioned it. You
religious
said-
philosophy?
You cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into play. So I just wanted to get a little bit of guidance from your position. And so
Now, this judge is a lot
that's the
more,
reason for the
No,
question.
I totally
clever than
appreciate the
I think
question.
people give him credit for.
I'm not suggesting,
he's
Your
paying
Honor, that there's
attention.
a problem with the question. Any question that the court asks is a question that counsel
I don't like
should
some
take
of his
seriously.
decisions,
The
but-
legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt. I didn't bring the Bible to this courtroom, the state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling? I appreciate the
He's going to
in-depth
rule for the
argument
state,
and
I
the
bet.
passion behind the argument. You are advocating for your clients, and I respect that.
Yeah.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
All right.
That's all.
All right, in making this determination
I'll
whether it's
decide at
admissible or
lunchtime.
not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed.
motive isn't even
and
necessary
that,
here.
Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant, what is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates
Why are
to
they talking
Charlie
about that
Kirk's
right now,
political
the
expression.
enhancement
And the
part?
court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point, when it becomes relevant, based off what Mr. Novak has talked about Mr. Kirk's,
What hasn't
Mr.
Novak talked
Robinson's
about?
state of mind about Mr. Kirk's political beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again, and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera. All right, let us proceed. Well, let us proceed to lunch because it is now 12:40. It seems like a natural place to stop. I believe everyone looks like they need a lunch break. So let's go ahead and break for lunch. Let's come back at 1:15. Well, I need to give you a full lunch here. I need to do my lawyer math and see what that would bring us to. So it's 12:40. Let's come back at 1:45 for lunch. All right. Any party need the benefit of the record before we break for lunch?
Not from the state, Judge.
No, Your Honor.
All right. Court is in recess until 1:45.
All right, cool. I'm not going to sit here. I'm going to go do my walking around. So I'm not sure. I'll just play for like an hour. Okay, I got to do something else. I will show this first, though. So this is what I fixed here. Before that, I fixed this right here. So this is you know what I could do is just have this looping around. I think I can have this loop. Yeah, let's see. Let me try to find that. How to loop the playback on Premiere. Let's see. And if the button isn't visible, click the plus button. Let's see. Oh, okay. Plus button icon. Drag the loop. I don't know what that means. Okay. I think it should be, if I hit play, it's got to be a loop button. All right, plus, there it is. And then what does the loop look like? Is it, oh, there's loop playback. There you go. And that is, oh, I don't see it there. Oh, you drag it, right? There you go. Okay. So there you go. We'll just play that over and over and over again. So that is, okay, so I think if, let me see what happens when it gets to the end here. Does it start over? Oh, look at that. Isn't that beautiful? See, I fixed this. I widened it out like it's supposed to be. And then I also moved the right corner up and the right lower corner down because the way it was filmed is like a trapezoid. Okay? But if you guys could please consider supporting the channel, we're having to ask again because we still aren't even close. Just another, we didn't have the 2 big hundreds that people did yesterday to just barely got us to where we needed to go. Today we are, still okay, but we need the support from the channel. Okay. These are the days we have to do better than other days. So I'm just going to play that in the music, and you guys can, but if you've been on my channel this whole time, you would see that it's absolutely identical to what I've been saying for a long time. I'm the one that came up with the dry run at 10:10, or 10:07, 10:08 while it's walking. It turns out that's a reality. They actually have them on camera walking around. And, the time at 12:23:28, I got that. What else? I mean, it just goes on and on and on, So I would appreciate you guys' support. It looks like it's just such a struggle for me, like, yeah. Shouldn't be. And yes, I'm really, I mean, that's my own problem that, like, when people type the same thing I just said, that I go, yeah, I just said that. Because it's just sort of like, it feels like people aren't listening, when I say something, and they just type the same thing in again. Or they type in exactly what I said. It's one of those frustrating things. I'll say something like, you guys, after doing the research here, I think Tyler Robinson did a dry run at 10:08 and then walked onto campus and probably left campus by around 11 because later on, 11:45, and then all of a sudden in the chat, 2 minutes later, somebody goes, I think Tyler did a dry run and probably like at about 10:07. And then he goes on, and then everyone goes, I agree. And then I go, well, how come you didn't say you agree when I just said it out loud 2 minutes ago? See, that's a feeling and something I observe all the time, so I don't really know how the hell that happens or why or whatever it is. It's just sort of a strange phenomenon. And then there's people who take the stuff out of my, yeah, that's right, Phyllis. And then there's people who take my videos and completely claim the concepts and ideas as their own and make whole videos and shows talking about it. And people watch it and think they came up with it, but they didn't do that. And so all of that combined is sort of this frustrating thing that I get. And, maybe I just shouldn't say anything. It just is what it is. He's got to be at least 6'3", man. He's got to be at least 6'3". Did you hear that? That sucker's Here, watch. Let me show you what this is right here. I'll tell you what, I'm 5'11", so let's take a look at this. We can just prove this shit right here. Hold on, I'm gonna go right in here. We'll go into the tunnel. See, this is the same shot, right? So I actually have my own version. Look at, my camera is placed right on the camera that's right there. You see that? So there it is, right? So I have my own version of the damn thing. And there's me. But this is it. I mean, this is the same damn thing. So we can go back into here, into the tunnel, right? So look at this. This is the shot that they have. It's crazy. Watch this. See, this is what I do that's different than other people. Oh, yes, later on when he does that. And I told everybody, watch. They have a footage of him walking through the tunnel on these cameras. Gray, you must have been part of it, man. Okay, right before this. Yeah, right here. See, unfortunately, their video kind of cuts off the video. But look at, so his head is, he's walking, and he's right there, right? So his head is kind of like high up on that. I don't know. It feels like, I don't know if that's all they have. I think they used this shot like right there, something like that, in their footage that they have out there. Okay, so that's the line. Does everybody agree? This line right there is the only line that sticks out. Okay, so let's go back to this again. See that? See, when you look at this, it makes him look really tall, right? Because that line is right there. And it's like, wow, look at his head. It's at the top of the screen. Holy crap, everybody. This guy's like 7'5". All right, but look. Here's the line right there. You see that, everybody? Pay attention, everybody. You see that? There's the line. And then I actually walk over there. I think at some point. I look like an idiot when I do that, but let's see, where is it? Okay, that must have been before that. Oh yeah, so I walk over there. Now look. See, I walk by, but I'm... yeah, but let's just go back to when I started walking, okay? When I'm over here. Look, my head's well above the line, right? Like when I go right to... Right there. Look where my head is. It's way above that line right there. You see that? There's the line. My head's way above it. See that? Now go back to this. And his head's barely above it over there. Hell, he might even be... I don't even know how tall this guy is. But you go over here and... It's not like he's this giant. He's probably, 6 feet tall, maybe, or less. Maybe 5'9", I don't know, what is he, 5'10" to 6 feet? Thanks, 6 Kids UK. All right, I don't know if you guys even, you see, again, you guys don't seem interested in what I'm putting out. There's no typing. It's just sort of Mystique, mostly just juice. Mostly juice. Best work I've seen, Gray. Hey, thanks. Yeah, well, go watch the video. I just put out a video earlier today about this surveillance. It's not really, it's just recorded the screen. But then there's links at the end, and you can see some of the videos that I made recently. What's the new narrative? Oh, yeah, that he's taller. Yeah. Yeah, well, I put out the truth. Other people put out bullshit. Okay? And that is the truth. Now, I'm only 5'11", so my head was above that line for sure. Right? Anyways, I'm going to play this music right here, and I'm going to play this. All right? So it's going to loop over and over and over and over again. All right? Yeah, I'd say he's like 5'10"-ish, That's about what he is. I don't know what his actual height. Let's see. I think I have that. Ba-da-ba-da. Oh, there it is. .5'10", there you go. Boom. So that looked like me. He was about the same as me, maybe slightly shorter even. Isn't that wild? Candace Owens, you're wrong again. You idiot. I could even, I'm not sure what the aspect ratio of this was. Look at that, there he is. So he kind of had that little backpack on the whole time. $9.24. So this is when he came back. So he came in on the second floor, and he's going down third floor. Yeah, that must have been. Oh, that's right. He's trying to get to his vehicle. That's on the first floor, I would think. Yeah, I just showed that, the height and everything. I guess it doesn't keep looping. let me play one of these other ones over here. I like some of these too. Hold on. Groove. Oh, the cool cats.
Eyes are back with a brand new invention, something rather holding me tightly, flows like a harpoon daily and nightly. Will it ever stop? Yo, I don't know. Turn off the lights and I'll glow to the extreme. I like the mic like a vandal, light up the stage. I like to jump like a candle, dance Those speakers that boom, killing your brain like a poisonous mushroom, deadly. Wanna play a dope melody, anything less than the best is a felony. Love it, leave it, petty game way, petty hit bullseye, kid don't play. If there was a problem, yo, I'll solve it. Check out the hook on my DJ revolves it. Now that the party is jumping, with the bass kicked in and the figures are pumping, quick to the point, no faking, cooking MCs like a pound of bacon, burn them, get quick and nimble, go crazy when I hear the cymbal with a hi-hat, with a souped up tempo, I'm on a roll, time to go solo, rolling, in my 5.0 with the rack top down so my hair can blow, girl is on standby, waiting just to say hi, did she stop? No, just drove on, kept on, girl zooming to the next stop, about to left, I'm headed to the next block, when I go dead, y'all, so I continue to A1A, Detroit Avenue! I'm a lyrical poet, Miami's on the scene, cause occasion to know it. My town, decorated by the bass sound. They shake holes in the ground, come my styles like a chemical steel. These are rhymes you can vision and feel. Conducting the form, which is a hell of a concept. You make it hype? Then you want us to print this. 3 plays on a phase, slice like a ninja, cut like a razor blade so fast. Or did you just say, damn, if a rhymes are a drug, I'd sell a polygram. I keep my composure while it's time to kick loose. Battery fast by the mic while I kick my juice. If there was a problem, yo, I'll solve it. Check out the hook when my DJ revolves it.
Hey, not bad, Mary Lou.
Thank you, Gray. Really appreciate it.
Trying to find one of these other ones in here. Wow, that sounds like Charlie's Angels music. No, Love Boat, Love Boat. The Love Boat, yeah. Exciting and new. Okay, what's this one? Okay, hold on. I'm trying to find a good one. I have a whole slew of them. That one's kind of cool. Okay, forget it. That is the Love Boat. Cool vibes, maybe? Yeah. I'll just play that. Turn down that. Yo. Man, not one super chat during that entire lunch break. Man, that is just, that is outrageous. Absolutely mind-boggling. Yeah, hey, everybody. Hey, look at, I Write the Books, or Hooks is back, everybody. We were all waiting. We all sat here and go, where is I Write the Hooks? We all sat here and waited, okay? And they're back, and they're letting us know, because we weren't going to continue the show unless they were here. Thank you for letting us know. Absolutely incredible. All right, is this going? I think it's a little bit behind here. There we go. All right. So far during this preliminary hearing, we have, I mean, there's so many things that if you guys have been watching my channel, I have the precise time that the shot took place. I figured that out on my own. 12:23:28, and then sort of a fraction. And then we have the dry run that I'm the YouTuber who figured out using shadow analysis that it was 10:07 or 10:08 when he walked by that house, not 8:07, like Candace Owens told everybody. And then because of that, it looked like he was heading the same direction he did on his final run, so I labeled that the dry run. And apparently, in that dry run, he walks all the way onto campus, onto the roof, and then back down the stairs again. I mean, so it absolutely was a dry run. Nailed that too. The screwdriver was found on the roof. Nailed that too. I mean, the only thing that I have wrong is I had him standing at the top of the stairs with the phone open for 3 or 4 minutes. So he obviously walked really slow. You could tell he was moving really slow in those videos. So. All right, so unfortunately, a lot of people didn't watch over here, so they wouldn't know. You know? It's unfortunate. Right, I'm the one that found the handprints right here. I mean, law enforcement found them, obviously, but I found them. I'm the first one in the public to find the handprints that were right on this ledge right there. As he lowered himself down, held on, and then jumped down. Okay, got that too. Now the footprint in the ground we heard about, that seems kind of crazy that you could actually get a print from a shoe type in the grass, you know. But we'll have to see how that panned out. Yeah, let us know if you take off, because we'll pause the show, okay? Yeah, as soon as you take off, we'll pause the show. We'll have to be waiting for you, unfortunately. So if you go to the bathroom and you're sitting on the toilet too long, we're going to have to wait 3, 4, 5, 6 minutes unless you had some Metamucil, where you might go a little quicker. We could start the show maybe in 2 or 3 minutes. But if you're not and you're having some problems, we might have to wait 6 or 7 minutes. So we'll be behind the rest of the public in watching the trial. Okay, so make sure to take your Metamucil. I Write the Hooks before we get started here. Thank you very much. Yeah, we know about that's what they say. He landed with so much force that he has a footprint in the grass, but I just can't imagine it leaving details of like the sole because there's grass there. You know, it's hard to picture that. If it was mud, sure. Yeah, I see it, you know. So, I mean, there's a footprint of somebody landing there, apparently. You okay, Willie? You sound kind of... gross, you guys. That's gross. Hey, Karens, if you can't deal with just goofy, funny conversation, get the hell out of here, okay? Man, people are so lame, you know. Just lame people these days. You know, they're the same kind that cry about all kinds of stuff. Yeah. Yeah. I'm not sure. Got a lot of your comments keep getting YouTube's holding your comments there. I Write the Hooks. Yeah. Gross. Well, you know what? You're the only one that mentioned poop, Fallen Rays. So maybe that's your fault. I never said that at all. I said, hey, you're on the toilet. Make sure to take that Metamucil because we might have to wait a long time for you to get back. You're the one that introduced that word, so you might want to check yourself. You know what I'm saying? All right. Thank you very much. Well, I don't care if you're eating. That's your fault. Hopefully you're not eating, what was that, on, I was going to say, what was that movie, on, shit, Caddyshack, in the pool, that kind of candy bar that it was floating around? Nah, there isn't enough dirt there. It's filled with grass. I've been there. Have you been there, you guys? Yeah. Yeah, we know that under the grass is dirt, but there's grass on top of the dirt, you guys. So you can't get it doesn't make the same impression like that. Whew. Yikes. And you always got people, they think they're just super sleuthy. Let's see, so what do we got here? Oh, great. So that, that shouldn't remind you of anything. Well, I don't know if it's from there. Yeah, Baby Ruth bar. There you go. I hope you're not having a Baby Ruth bar for dessert. Yeah. He jumped from 10 feet onto grass. It'd be really difficult to have an impression in the mud below the grass because there's grass there. That kind of it would pop back up. Now if it was really muddy and wet, maybe, I guess. Didn't seem like it. So I guess we'll have to wait and see. What do you mean fast set concrete? What are you talking about? Oh, you guys are... it's not called concrete. It's a plaster that they put down. Yes, you guys, they put down concrete, weighing 80 pounds. They're lifting this big sucker up when they're getting the... Yeah, it doesn't really matter. Yeah. Doesn't really matter. Here's the truth. His screwdriver that he left on the roof is going to have his DNA on it. So, of course, the screwdriver was found right near where he put together the rifle, right? And then when he's coming off the roof, I wouldn't be surprised if when he dragged his hand off, if they didn't get DNA from that drag mark. And then he hits the ground, and sure, okay, yeah. I mean, it's almost overkill to be talking about the shoe print. It's consistent with, they said. I was thinking there was a shoe print on the ledge because he put his foot on there like a partial print just for a moment. That turned you off of that candy? It was a joke, though. Why would it make you not want to eat it? I think I've had like one Baby Ruth bar my entire life. I don't think he'd have like gunpowder or anything. His feet were way behind him. Oh, you mean like dust from the roof? Maybe, yeah. I mean, they'd have to find his shoes, if they didn't wash him. Remember you went to the car wash? Maybe he did something there. Yeah, well, I don't know. I mean, yeah, you could say that by leaving the screwdriver up on the roof. Well, he was screwed up anyways because his face is on camera. All right? Let's just pretend that they didn't find the rifle in the woods. But they were somehow able to find somebody, on the roof walking around. Then they backtracked it all the way back to the parking garage. And they would have been able to do that, right? Because you have this guy limping in front of the Losi Center building. So you go backwards and you find somebody limping in the garage. Then you find somebody limping into the tunnel. And then those are the images they put out there. Then his parents would have said, yeah, that's our kid. Wow. And so he's the guy on the roof running to the corner there. And so then you'd say, well, it looks like he has an elongated item. But yeah, it'd make it a lot harder, but you could get to a really strong circumstantial case. especially with his notes, right? Saying what messages were on there, what he said, etc. There's a lot of things that that he did that regardless of one of the elements, it makes it still really strong. That's why I keep telling people this is one of the strongest cases I've ever seen in true crime. It's literally, there's nothing that, quote, just doesn't add up. People say that all the time. They're lunatics. They say that because they want you to go, and then they propose something ridiculous to you, like putting pavement down, covering up the spot where Charlie Kirk was shot, and insinuating there's a tunnel there that somebody came up and did the real shot. Those people are crazy. They're supposed to be back at right like now, right? I thought 1:45 they were supposed to be back. So he might be having like an in-chambers meeting. Maybe he's changing his mind on something. Who knows? I mean, they're not back, right? I mean, I'm kind of checking around. I don't know. I can't see it. Let's see. Oh, yeah. I think they're just started like 2 seconds
Noting the
ago.
presence of
Hold on
all
a second.
counsel and all
Just
parties.
started. Okay, hold on a second.
All right. Mr. McBride, turning to the state.
Yes, Your Honor. Just by way of preview, we are going to call Jen
I like
Falmuina,
that. It zooms in on these guys.
Sergeant with the SBI, but how we're going to proceed is we're going to call her for a very limited purpose. We're going to pause her testimony. Defense is not going to cross at that time.
It started like
and we're going to
30
call
seconds
an
ago.
FBI DNA analyst out of order. It's a defense witness.
I'll speed it up just to
but that's
catch
to
up.
accommodate that witness's schedule. State calls Sergeant Jen Falmuina.
I'd like to come forward and be sworn in.
Yeah, I'm playing it. Yeah.
Do you solemnly swear that the testimony you are about to give now before the court will be the truth and whole truth and nothing but the truth, so help you God? Yes.
All right. After you're situated, there should be a bottle of water to your left, maybe behind the monitor. And if you wouldn't mind just bringing that microphone just a little bit closer to you so it picks up your voice for the recording. Mr. McBride, your witness.
Will you please state your name?
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department of Public Safety.
What position do you hold there?
I am currently a sergeant within the State Bureau of Investigation.
What was your assignment September 10th, 2025?
I was assigned to oversee the crime scenes as well as the physical evidence.
And were you sergeant with the State Bureau of Investigation at that time as well?
Yes.
And do you have any kind of specialty in your assignment there?
Yes, I do. I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we hear ERT, it means Evidence Response Team.
Yes.
Were you called to the crime scene at Utah Valley University on September 10th of 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped process?
Yes.
We've had some testimony about the rooftop of the Losi Center. Did you oversee or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our State Crime Lab.
And do you know what happened to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent? Do you know?
It was sent back to their equivalent of our crime lab.
Okay. Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry. That would be a rifle. So to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt
It was a
action?
bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe, and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items, well, let me tie up that thread. The gun, what was done with the gun?
This is a
The gun was
setup, you
packaged,
guys.
it was taken to FBI custody, then eventually it was provided to the ATF lab.
Okay, so the gun went to the ATF lab, is that correct?
Yes.
The towel went to the FBI lab,
Yes.
and the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31.
Oh, sweet. Do we get to see it? See, we should be able to see all of these. These aren't.
I think that's connected to the defense computer right now. Is there any way to switch it?
Okay, that's the main monitor.
Thank you.
Now they're going to show us. Sweet.
Okay, I'm showing you here on the screen State's Exhibit 31.
Hand the camera, you idiot.
Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmuina can observe this exhibit. If I can have just a moment. And can you see who that report is signed by?
Yes.
Who's that?
Amanda Baker, I'm assuming is how you pronounce her last name.
Is that, in fact, the report that you received documenting the testing results on these items and some other items from
Yes.
the FBI?
Sorry, yes.
And does it appear to be in an accurate condition as to how you received it?
Yes.
I move the admission of State's Exhibit 31.
Defense?
No additional objections.
All right, so I'll note the standing objection, and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
Hold on. I'm just trying to find something.
Anything further, Mr. Bird? All right. The court will admit State's Exhibit
See if we can see it.
31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen.
There we
in
go.
the
We get to
courtroom,
finally see something.
and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to
Oh.
page 1.
I wanna see the
screen will show
picture.
items 7 and 8. Sergeant Falmuina, do you see the lines there that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, towel
Oh.
from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it
On
is.
September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from the title item 7 until the word contributors?
Yeah, it's cumulative. We have the analysts here who can describe it. Not sure it assists the court to be having her read from the report that's already been evidence.
And would you mind repeating that, but with a microphone? I want to make sure that the record picks up your objection. All right. either way, if you want to come up, that's fine, Mr. Burt.
Judge, the objection is that her reading to the court what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So we've got the report and evidence. We don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right, the court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7 sub 1 and are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1.
Twiggs is on there. Oh, my God. He must be the guy.
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you.
Just a
couple of
screwdriver
foundational
inside their
questions
house.
Before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And
Twiggs wasn't there that day.
Lance Twiggs'
They just live in the same place, just like the towel.
For comparison in this test.
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
All right, Mr. Burt, cross-examination.
Your Honor, I'd like to reserve the right to cross-examine after the witness completes her testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the parties?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you. All right, Mr. Burt, turning to you.
So let's see.
Your
The
Honor, out of
DNA
order, the defense would be calling
is on the screwdriver on the roof
Amanda Baker.
All right.
of
Ms.
Tyler
Baker.
Robinson. So Tyler Robinson's DNA is on the screwdriver that was found on the roof where the rifle was assembled. So that places Tyler Robinson on the roof. It doesn't place Lance Twiggs there because there's no evidence that
All right,
Twiggs
Ms.
was
Baker,
there
if you wouldn't mind coming
at all.
forward, right up here by
Tyler
the bailiff.
Robinson's
and being
vehicle was
sworn
in town, etc. You know, it's just such a clear. That's why I'm telling you guys. This case is. Can you guys type more, please? You know, it's like it's been 3 minutes since another comment was made.
The whole truth and nothing but the truth. So
That's why I keep telling you guys. If you're not communicating in here,
Ms. Baker,
YouTube
if
just
wouldn't
casts
mind
you
being
aside.
Seated at the witness stand. once you're situated, there should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice, okay?
Okay.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we
Okay.
could. While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled Bakker.
And Ms. Baker, what do you do for a living?
That's pretty good.
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into the DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority one level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high-profile nature of this case, an item of evidence would be submitted to the lab, it would be inventoried by our evidence management group, and then sent to the various units for testing, for example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files?
Yes, I do.
And document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All. Spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to exhibit number State's Exhibit 31, which is in evidence, and I think it's our tab 2. And that's in evidence, so if you could display that on the screen.
Mr. Byrd, are you requesting it to be displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that, and this will be just to the witness, not to the public.
Okay.
Calling up tab 7. Do you see that on your screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says 1 of 6.
Yes, so this would be the entire document.
Mr. McBride?
Your Honor, I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
Your Honor, the document is referenced in your report, and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes, correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct. No, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct. It was not.
Okay. And then the next one, not that one more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a zero error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a zero error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
You can
sorry.
take that down.
Can you clarify your question?
Yeah. When it refers to don't state that there is a zero error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Mhm. Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the biggest one.
Okay, so not to go onto this main big screen.
Correct, this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4, fourth down, one more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Yeah, it's just 1 in 10 trillion. So there is that 1 in 10 trillion that you could. That's how stupid this kind of stuff is.
Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does the DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat, an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data? So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, Item 7 was the tau. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information, I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of A, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length?
Correct, yes.
Okay. Now, for the, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex-determining locations. That lets me know if an individual is biologically a male or a female.
As between 2 individuals, 99% of their DNA is exactly the same, right?
That is correct, and that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is what differs amongst us, with the exception of identical twins.
But with the within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex determining, so 24 total.
What are the sex determining, they're called the locus, correct?
Correct. So locus is that individual section of DNA.
Right, and they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex-determining locations. One is Y-indel, and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay, and then for the other locations you're looking at, those, you're just looking for 2 types at each location, correct?
Correct, yes.
Okay. Now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations?
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low-level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes, so for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother, one from your father, but when you say he's an 11.
Robinson was an 11.
And I think you
What
said.
did they edit out right there? You guys see that blackness that came on the screen? What did they edit out? Wow. What did she say right between there?
He's what's called an 11-11, correct?
God.
So for this, so
Let's
DYS
hear if we can hear the
391 is actually that male location, so he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now, for that loci, you'd expect 2 types, correct?
That is correct.
And when you say
It's
he's a
loci.
17,
Okay.
do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
You probably shouldn't watch then, right, Roxy?
At the TPOX location, Mr. Robinson's a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11.
That is correct.
But when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing 2 samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing,
Yes.
all right? And then by the same organization, National Research Council, the Evaluation of Forensic DNA Evidence.
Objection,
Correct,
Your
yes.
Honor. We need the author of the book to come in here and
As well.
Yes,
talk
I am.
about it. We need the
And
author to
there's
come
an
in.
author, I believe, who
It's hearsay, sir.
does research work at the FBI, named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and
Okay,
your
well-
continuing education.
That is
Why are you
correct,
still
yes.
here if it's
He's
so
got
boring? I
three
mean, Jesus,
current
why would you
textbooks on
torture
the
yourself?
topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA.
Again, a repeat objection, Your Honor. We need the author to come in and
Forensic
explain the
DNA
book.
typing methodology.
Yes,
It's
I'm
just
familiar
not,
with
it's
that one as well.
really unfair,
And forensic DNA typing interpretation.
unconstitutional.
Everybody in your field relies
It's
on these
hearsay.
publications, and use them as teaching tools.
Yes, I would agree with that.
Gray, we couldn't hear a
And then, in
word
addition to
he
those books, there have
said.
been studies that have been done on particular topics, correct?
Yes.
This case, we're dealing with mixtures, correct?
Yes.
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
Not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far
He's
as
not.
it being
I've already
difficult,
proved it, you guys.
you can have some mixtures
already
where there's
proven the
one
guy in the
contributor
videos, he's
that
shorter than
donates
me.
a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible, so I could have low quantities of multiple individuals, which is simply just saying that I can't determine
Well, they have
which
medication
piece
for
of
that.
DNA goes with which individual, so that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is dropout?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have
He
a
wasn't
person at a
involved.
particular location that is a type 1415,
He touched the same screwdriver
because of
and towel
degradation, that 15
that Tyler
drops
Robinson
out,
touched because they lived
What you're
together.
seeing on your chart is
Or
just
they
the 14.
were boyfriend. Yeah, I
That
think
is
they did
possible,
live
yes.
together. Yeah.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident, based on our validation, our testing, and my training, that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 14, 15, I will not automatically exclude them.
What is stochastic effects?
Stochastic
I'm
effect.
going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right.
I think
Mr. Burt?
I think it goes directly to the reliability of the testing results that the state
Yeah,
introduced.
people always try
I think
this
the
crap
court
with
has to
DNA. It
understand
doesn't
the
work.
Limitations and
You know,
potential sources of error in
It's
order to
ridiculous.
assess whether these results are
It's
reliable.
1 in 10 trillion. So yes, there's a
And
chance that some
in regards
alien from
to
another
this
planet
line
that
of
has the exact same
questioning, how far are you
DNA.
going to go on this line of questioning?
I have this one question and then I'm moving on.
All right, Mr. McBride.
I'll hold them to that.
All right, well. Mr. Burt.
The judge
so
holds
the
him
objection
to
is
it.
overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about
That's pretty good.
stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have
Well, I'm adamant sometimes,
alleles
but
that are
I'm right. That's the
copied
difference.
better than other alleles.
Phyllis, so there you go.
Okay.
I do the
Now,
work to make sure that I'm
another
right
topic.
on something.
I mentioned studies before. One of the studies that you're familiar with is called the PCAS report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAS report is, PCAS stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAS report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples.
That's
that
another
had
question.
certain
You said one
characteristics,
question.
That is correct, yes.
right? Including mixtures where
Not topic.
what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAS called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and
StarMix
it
software.
uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates the likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to StarMix?
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
And how about for the other sample?
7%, and the
I got
other
edited something
99%.
again, you guys.
So below 20%, right?
Correct, yes.
And the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAS report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of Investigation?
Objection, Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are the court weighs the evidence in the light most favorable to the state and avoids
Everybody knows.
credibility and balancing the evidence to the stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability, and it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the favor most in the light most favorable to the state. And I think we're beyond that point now. We're getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to...
What are you guys talking about misgendering
we'll
and
just
stuff
leave
like
it at
that?
that.
I don't get it.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAS report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now, that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training, looking at the data. That's something I input into StarMix.
Right. And that's a complex determination, is it not?
Not necessarily.
But but it can be in some cases, correct?
It could be if there's mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same. It could cause some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce,
I believe so, yes.
federal agency.
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors,
This is so stupid.
Improving Practice Through a
The
Systems
FBI
Approach.
did this.
You're familiar with that publication?
They know what they're doing.
I am, yes.
And was that a publication written by scientists?
I don't
thanks up
recall
there to
exactly
Phyllis
who the authors
Watson.
of that publication were.
For the,
Okay,
what was it, gifted member, or, yeah, gifted membership?
make sure.
Well, while they're digging around, you guys, if you can help support the channel, I'd really appreciate it. You can see that we're really struggling today, so we got to have this worth the time to spend 8.5 hours sitting here. So I'd appreciate it. That we don't have a lot of
long
people here,
report,
so
right?
it's
Yes,
hard
it
to
is.
just have it happen
read it.
organically.
I've read highlights of it.
Is it true that one of the things that they say in that report is they have a section on the complexity of number of contributor estimations?
Objection.
Maybe, Carl. I don't know. I don't know, man. I don't know.
This is beyond
I don't know.
the scope of a preliminary hearing. Again, we're talking about
But thank you. Whatever you
expert
feel like doing.
reports,
right?
we're talking about scientific studies. These materials are all fine to consider at a 702 admissibility hearing. At this stage, where, again, the evidence is viewed in the light most favorable to the state, this is unhelpful to the court's determination, and therefore irrelevant to this proceeding.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, I think the report that the state put into evidence, as clarified by this witness, indicates that she reached the conclusion that Mr. Robinson and Mr. Twiggs were,
What is this
quote,
thing?
possible
Why is that just sitting there? Oops.
contributors to these two samples. And so the one thing the court has to weigh is what is the weight of that opinion, given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And
I'm
as
not
an offer
sure.
of proof, I'll
Will any of you
indicate
guys
to the
join in
court
on
that the
Carl's
numbers
challenge
derive
if he does
from
one?
this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of
Right.
contributors
Twigs will be on there.
is
And he's a
changed.
minor because he wasn't touching
And
it
in
last.
this case, as I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis, and will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in
What are you
these
talking about? I read the books.
astronomical numbers.
You're ridiculous. I never said
They're
anything.
asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
So the concern that I have is, I turn to State v. Ramirez, 2012 UT 59 at paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is a matter of fact-finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate, I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is as we go down further down this path, which again is not precluding if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause stage?
Sure, and I think the answer to that is we have to take into account the ruling
I don't
that
know.
you
Carl
made in
hasn't
this
said what a
case,
challenge
which is
would
the
be.
law of this case.
I don't know.
Which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. It's, is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling.
Thank you very much,
Which is
Carl.
that your
That's very
role
kind
here
of you.
is to determine reliability of evidence. And I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments. Whereas I'm focused on what the court ruled, which is we have to look at reliability here. And that's my job.
Well, we got a challenge
as
up
a
there, you
magistrate.
guys.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B4, this, the Exhibit 31 is considered reliable hearsay. In addition,
Thank you.
credibility determinations are not proper for the court to make here for the whole reason that, studies
Thank you, Anne-Marie.
supporting this science, studies opposing this science.
Phyllis Watson.
Testimony from this expert
like
or
saying
that
that
expert
name.
about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple-day
Yeah, thank you.
hearings
Appreciate
dealing
it.
with that. And
Appreciate
a
you.
probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury, in the end. That all supports cutting this line of questioning off at this point rather than going on for into greater depth, Your Honor.
All right. Well, based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure. Did that NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So, like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4
Thanks,
individuals.
Jamie.
I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes, and could you display for the witness page 365 of tab number 4? And And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we
I'll do the
don't
last
expect
one.
that
There you go.
math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile, if I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood.
Hey, thank you so much there, Carl with a C, and all the freaks who reached the challenge right there. So thank you, guys. And thank you so much there, Carl. That was really generous of you there. We've been really struggling all day long, and that helped out tremendously. Thank you.
Star Mix utilizes math and distributions. You will never get the same answer twice, but it will be no more than a magnitude of 10.
So that test is not reproducible in the sense that you can run it, a sample, or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run Star Mix, I'm not going to get a likelihood ratio of 10, and the second time get
And welcome to all the new people there.
10 quadrillion the first time,
10
2
quadrillion.
quadrillion the second time. But even if I run it 10 times, I'm still going to get
that's a
around
lot
the
of
same likelihood ratio
planets.
value.
There's only 8 billion
Could you
people
look
on
at,
Earth.
Tab number 4, your case notes at page
But thank you,
365.
Carl with a
Bring
C.
that up for the witness.
What do you think of this one? This case is so,
Let me know when you have that in front of you.
I mean, it's just so obvious, it's
You scroll
ridiculous.
up.
It's scary to me that
Front
there's
page.
people that think something else. Because there's nothing that would indicate to think something else.
There we go.
Terminus,
Can you identify this page from your notes?
Walking Dead.
Yes, I can.
Man, that was
These
a-
were
that
notes
was a
that my
creepy
technical
town.
reviewer made. And my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons, then compare it back to my conclusions.
All right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to this sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms or the name for the output of this technology you use,
Carl with
correct?
a C.
She utilized the same electropherogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation of your case file?
Yes, it is.
If I move into evidence, page 365, and that would be Baker 4.
One question with
I'll object on relevance grounds.
6,000 sub
All right, did you want to
parts.
respond, Mr. Burt?
Your Honor, it's relevant
Reminds me of Back to
because,
School with
the
Rodney
witness
Dangerfield
originally determined that.
when they asked that
3
one question.
contributors. And I'm like
Question
to
number
explain to
1,
the court how she reached that conclusion.
with
because I
62
think it
parts,
does
or whatever the
go
hell the
to
phrase
The
was.
reliability of her testing here.
All right, so as it relates to
Remember that? Rodney Dangerfield?
Baker 4.
Back to School?
And this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, these notes were prepared as part of the report in State's Exhibit 31.
Get this guy out of here.
Your Honor.
Relevant,
It's
and
not- it
it
doesn't-
is
it's not doing
admitted into
anything.
Evidence
It's
as
a probable
regards
cause
to
hearing, for God's
publication.
sakes.
What is the request?
Your Honor,
Mr. Byrd?
if I may clarify, I think the testimony was that this was not her notes. That these
I-
were the notes of her technical
Did
reviewer.
you take off,
is what
Carl?
I heard.
I wanted to say, I was saying thanks. I don't know if you're
Please
still there.
correct me if
but
I
want
misheard
to
that.
Make sure you heard
From
me.
both sides. I want to
Yeah, I
make sure,
did.
I want to make sure, are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer that you relied upon.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
All right, I'm just trying to put it together here. So the question I'm trying to get to, counsel, is, was this particular, I recognize it as it being prepared by someone else, but as it relates to States Exhibit 31, was this relied upon in order for States Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that, and that's a crucial point I don't have the answer to just yet.
Okay. Let me lay a more adequate foundation. The case file notes are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any crossouts, there's dates and initials and so forth. Those two reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
And in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
And that is correct, yes.
Right. And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say a number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually I have one reviewer. So in this case, at that particular time, I had a reviewer. Then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
But you certainly took into account this notation on this page before you changed your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation, and again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business?
Yes.
And they're part of the case file that you rely upon in reaching your conclusions?
They are kept with the case file after I draw my conclusions.
So, Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
All right. Anything further from the parties before I weigh in on, make my ruling on Baker 4?
No.
The court finds that it is relevant, and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published
All right, in the courtroom.
in both the courtroom and to the cameras.
All right. Any objection, Mr. McBride? All right, go ahead and publish that to all screens.
These defense attorneys are embarrassing. I mean,
So,
really,
These notations.
they're not even really, they're
at the
just
top there,
mucking, they're
7-1
just sort
male,
of blurting
discuss
around.
3
It's not going to work.
NLC and OK
None of this
with
is going to do a
3.
damn thing. None of it.
Could you translate that for us, what that means?
Sure.
He didn't think she'd
when
say
my
yeah.
technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. She compared it to my conclusions. I said number of contributor 3, so we had a discussion as to why she thought it was 2, why I thought it was 3, and she said she agreed with me calling it 3 based on our discussion.
Okay, so was that an extended discussion you had with her, or just?
No, this was a quick
So I guess maybe
discussion, and
there's
this
a
is
third.
not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it
we're
is.
Talking about? All right, thank you. Now, I want to ask you to look at page 128.
And Murdoch, we need the
Same
crunchy
exhibit.
sound. We got to have the crunchy, like the. Opening up the exhibit.
No. Is this an electropharogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
Remember that shit? Remember, you guys remember that, right?
I'm
That was
sorry, there's
crazy
nothing on
shit.
the screen. It might,
The whole show, the whole trial was just. It sounded more like this, though.
yes, it is.
I moved that into evidence. This would be Baker 4,
Right?
page 128.
It sounded a hell of a lot more like that one.
Oh, I thought I already admitted Baker 4. Is this a different?
Oh, man, that was.
The previous one
That was kinda
Baker
cool.
4, as I understood it.
Yeah,
and
I like that
Baker
trial.
4, page 365.
Oh, okay. So
And
Baker,
so this is Baker 4, page 128.
right, so
I
the
think Carl
previous
just
admitted
bailed right
exhibit
after
is
supporting
Baker
the
4,
channel.
365.
Well,
The
thank you
current
out there, Carl, with a
program is
C,
Baker
if you're still out
128.
there.
That's correct.
All right, Mr. McBride.
If I could have just a minute to update my notes on those page numbers.
All right.
Yeah, that's how it sounded, that last one. Like these
365
plastic
was the
bag kind of
previous
things.
one, unless I heard it wrong.
Yes, that's right.
All right, and the current one is 128.
First, I'll note, this is the first I've seen.
Oh, okay,
I'm
cool.
seeing
I just wanted
these
to
as
make sure that you heard me
exhibits.
say
Of
thanks.
course, I have this file, but I was unaware that we were going to be, these are going to be offered as exhibits, so I'm looking to find them in my file as we go. Second, again, I'm going to object on relevance grounds to the probable cause determination. We're going through the finite details of the analysis here. And once again,
It's
I
not
think
gonna
these are
sway
appropriate
anybody.
questions to raise in a 702 hearing. But with the standards that apply at the preliminary hearing that I've already discussed, I think we're beyond the scope of probable cause determination as we dive into this evidence.
All right, Mr. Burt.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropharogram is and how it's interpreted.
Who cares
And this
what an
particular page will illustrate to the court how the analysts interpreted the peaks on this electropharogram to reach the conclusions that she reached, that there were 3 and not 2 contributors.
Pretty mangled
I think
up
it will assist the
model.
court in determining exactly how this comparison process works and what the output looks like, so the court can see exactly how the interpretations are being made.
It's a probable cause hearing.
And is this the notes that were relied upon so I'm viewing State's Exhibit 31 as a summary, and this more of showing the work of how the summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. And she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent, and that people can read these things in different ways.
It's not going to convince them overall that DNA
I think it will help the court understand exactly
It's a
what's
probable
being
cause
compared
hearing,
here.
though.
You've got peaks on a line.
Yeah.
She will say.
The judge has to
and
be
just to let the court know in responsive to
sustained,
Mr.
you know, on this
McBride's
one.
statement
This is
that
stupid.
he was unaware that
I agree
this
with
is
the
going to be an
prosecution.
issue. He and I met with this analyst before.
This is like too
the
deep of a
preliminary
level
hearing.
of digging.
The analyst
in
pointed this page out
for
to
something like
us
this.
as being illustrative of why she originally concluded that there were 3 contributors. So this is not something that's being sprung on the state. He was a part of that conversation, and this particular page was identified by the analyst, not by me. So it is important to understand why we went from 3 to 2 and what impact that has on the numbers that the state is offering.
All right. Anything further?
No.
All right, under Utah Rule of Evidence 1102, B4, it says scientific, laboratory, or forensic reports and records. I find that this is admissible and is admitted into evidence as Baker 4, page 128, and is a request to publish this document.
Okay, you can.
Was that a yes? Oh, okay.
Yes.
All right, so published, I'm assuming to that
Yes.
screen as well? All right.
Correct.
It may be published. Counsel, just as a reminder, as this is a probable cause, I understand and I appreciate you give me a pointer of where it's going, but just as a reminder, as probable cause, it is admitted, and you may discuss it, but I definitely want to keep this within the track of probable cause.
Understood.
All right.
Thank
Thank you, Mr. Burt.
Okay.
So he's allowed to keep going?
Is it true what I just told the court, that you pointed this particular page out as illustrating why you originally thought we had 3 contributors?
Yes, that is true.
So explain to the court, is this an electropherogram?
Yes, this is an electropherogram. Each of those rectangles at the top, for example, D2S441, that is that
Like
small
totally.
segment of DNA that I referred to earlier. And each of those peaks has a corresponding number that is the allele, so that corresponds to the number of repeats that an individual inherited.
And this is what you ultimately, after, you get this
Oh my
electropherogram not
God,
through running
awkward.
it through STR mix. There's a different device that you use to produce these electropherograms, right?
Correct, yes. During the DNA process, this is the last step of that process. So what it's doing is DNA is found in cells of our body. We're taking those cells, we're breaking them open with chemicals to release the DNA from those cells. We're making photocopies of those pieces of DNA so that we can essentially see them. And then the last step is to separate those pieces by size, and the ultimate output is this electropherogram.
Okay. And is it true that you set the parameters for what the machine will pop up in terms of numbering the alleles?
Personally, I do not set that up. That was done during our validation of the chemicals and the software and the instrument that we utilize. But there are parameters. So the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
I want to make sure you answered that. You set, or your lab sets, what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process and the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold, and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize. That says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. Any peak that's below the 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct, yes.
So you could say, and you referred to a measurement, you refer to that as RFUs, right?
Yes, that is the unit.
What does that mean?
It stands for relative fluorescent unit.
So in your lab, you tell the machine only label peaks that come above 150 RFU.
The software that utilizes the information from the machine, yes.
However, it's true, is it not, that in determining the number of contributors, you look below that 150 RFU level.
And that is true, yes.
All right, now on this is only showing 1, 2, 3, 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see, so how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433, and as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine, could there potentially be a third person included? So for example, at D2, the location farthest to the left, I'm asking myself, that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
Well, I got a call from Candace, so no, I changed it. Yes, if you combine the alleles with the ratios of 2FC5, you'll notice that there's a correlation not only between the 2 contractual elements of the 15th Circuit Court of 1972, but you'd find
I changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
You use the phrase elimination sample. That's typically used, is it not, in a situation where you're testing a sample that has more than one contributor?
Not necessarily. An elimination is just simply an individual that we're expecting their DNA to be there. So for example, if we have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than one individual. There certainly has been times where I only detect that known expected individual.
And you said you had a conversation with the investigators as to whether Twig should be included as, or you talked to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay, but in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs?
That is correct, yes.
Yeah, that's how it works.
You didn't just
Yeah.
assume that, you reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared him to that DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical
Oh, you have to click on membership
calculation.
and make
I'm
yourself
letting the
available.
software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor, do you not?
I do, and with elimination samples, that's slightly different. So for example, let's say I have a sexual assault case and I have a vaginal swab from a female. She has a consensual partner. I can request an elimination sample from that consensual partner. If I see that they're present, I can say they're present and say the DNA foreign to that victim and that consensual partner is one person, for example. So it's different than comparing a known individual. If they're an elimination sample, I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, they are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect in those two samples?
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly, but in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Right, did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs's DNA to be present?
That is correct. It was found outside of a home, but again, based on speaking with the investigators, they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
Right. And again, you didn't assume that, you actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Tell the court what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up STAR mix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this HP is the prosecution hypothesis, right?
Correct, yes.
And HD is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have a defense postulating what their theory is?
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of 2 hours. Would right now be a good time to take a 15 minute? All right, let's take a 15-minute break. Let's see. We'll come back at 3:50. Court is in a brief recess.
You hear the way he hit that gavel? He's like, this sucks. You see that? He goes like this. He puts that gavel down like, oh, shit. Listen. Now, I'll tell you what, if that 15 minutes is any like his first question, they won't start court up again until next month. Well, sir, I've only got one question, okay? I've only got one more question. And you know what happens? You cut to the next scene, and we all look just like this. I mean, it's incredible. We were just sitting there, young people. And he said, can I just ask one more question? And after that was done, this is what we look like. That's incredible. Unbelievable, man. I'm telling you, this is... it's crazy. What in the hell was that? It's so stupid. It's a preliminary hearing. Nothing you say in that preliminary hearing is going to outweigh the 51% burden on DNA. It's stupid. Nothing. I'm going to finish eating up this part of this hot dog here, so...
By quad area.
Sorry, the amphitheater.
Boy, that looks like our son Tyler. Oh, no problem. Yeah, it gets a little bit frustrating in here. No, it has relish on it. It's got sweet relish, mustard, hot dog. That's all you need. I almost had a chili dog, Carl, because I have a can of chili in there. And you know what? I was supposed to eat that. That's what's weird. I forgot. You know who makes really good pizzas? I've said it before, but it's pretty crazy. Go to 7-Eleven. They got those pizzas back there. And then you bring it up to the front. They cook it for you right there in 2 minutes in this little machine they got. And it's pretty good for what it is, man. I mean, like $8 for this freaking... The crust tastes good, the whole thing. I try to avoid those, but... Yeah, I meant to do that because I have a half a can of turkey chili in my... Hormel turkey chili in my refrigerator. And I actually had meant to eat a chili dog, but I forgot. Isn't that weird? So thanks for the reminder, Carl. Might have to have another one a little bit later. Darn it. I don't want one, you know. I don't want another hot dog, but I feel like I have to have one because I've got that can there. Yeah, so if you guys have missed it, check it out. The highlights from the last couple days are that everything that I've been telling you guys has been validated. The only thing that I didn't get right was how long he stood right here with his cell phone. Okay? That's it. Let's see. Does it pick it up? Yeah, there it is. So he's on his phone right there. Put the phone in his right front pocket. And look at that. Oh, yeah. Can we make out the gun or anything? Let's see. So the gun, it would be in his right leg. I bet it goes down the back of his leg. Let's see. Does it right there? So he keeps that totally straight going down. So actually, I think it goes to right there. Like that's the barrel there. And then down, and look how straight. Well, no, it can't be that because it would have bent there. So maybe that's not, I don't know. Maybe it's in the back part of his pants that go up the back. I don't know. But he's obviously has something in his pants the way he's going down those stairs. But seriously, though, listen to this, you guys. I'm not sure if you guys have been following along. It's just... so, first of all, I mean, one of the elements was that the screwdriver is found on the roof near where he put the rifle together. That's what I said all along. I thought it was going to be in that little thing, but it was just outside of over that wall. We got that. And then, during this, we heard that that's what I was going to do. Hold on a second. During today's hearing, I can't remember what the first guy that was up during the day, he told us that the gunshot took place at 12:28 or 12:23 and 28 seconds. Now watch this. I'll go right to 12:23, right here, and then watch my thing here. Watch.
So much. So before we had a flag and we had it, so it was positioned above the tent, so it would be in the camera.
There was 12:23:28 on the screen as it fired. So it's 12:23:28 and like 2/3 of a second. Isn't that crazy? So he said that. So I got that time right by using Bartholomew's video. I had to contact him a few different times until he gave me the precise metadata time that his video started. And then what I did was he knew what the time it was. So then I put a clock on the screen and matched it with that time. And then as we got to the shooting time, it was 12:23 and 28 seconds. Not that that's like, oh, wow, who cares? Because it really doesn't matter, like, in the seconds and everything. I'm just trying to say that, like, it's just something that we got right, and everybody else was still trying to. I had a guy kept contacting me on Twitter going, well, I'm not sure, Gray, because I've got this and I've got this. And I go, dude, this is what I have, man. And it is. It's 12:23:28. Then, you remember my shadow analysis that I did? I think that's in this video. Right at the end. or maybe it wasn't in this one. But also when we were watching, this right here is exactly what they showed on surveillance footage. Tyler walking just like this and entering the building. They stopped it here, but if they kept filming, they would have shown him go into the building. All right? They have that. And then they show him running up on the roof. It's crazy. Like when he goes up on the roof up here, watch. See right here? They had this exact shot on camera right here. Just like that. Isn't that nuts? Like they literally have that video right there. And I already put it out there because I knew what they were going to have. So that worked out. And then, remember my shadow analysis that came up with the 10:07 or 10:08 time frame where that video was taken of Tyler Robinson walking near campus again. You guys know which one I'm talking about, right? This video right here. It's in this one right here. So you see him right here at 9:57. And then I have his whole, like from his point of view, it would have looked like this. And he goes around. And then right here, people were saying this was 8:07 in the morning. I'm the one that put out that it was at 10:07, 10:08. I have 10:08. Okay, and then he walks this direction. And then check this out. Watch this. So here's the new footage. And we have to go back because it's earlier. Watch this. So it's after this. So he came back on campus later. It's this one right here. See, look at it. Look what time it is up there. You can see it. It says 10:09 and 25 seconds. So here he is right after that, walking down the stairs. Okay, boom. And then they're going to have him coming down the tunnel right here. And look at that, 10:09 and 43 seconds. So that's absolutely nailed right there. Like that was a dry run. And he went on and described it, saying that he went on to campus and then he eventually went onto the Losi Center building into that walkway, went to the edge of the fence, looked, and then turned around and came back. And then that time frame actually matches that footage we have of from an aerial shot of the Dodge Challenger parked in the neighborhood. Isn't that crazy? I mean, it all works, man. So that means he moved it for that. Are you guys there? Hello? Yeah, so literally, I would say every single thing that we've been saying has been validated. The only part that, I've heard about was they jumped off and then made a footprint. I wasn't sure. We heard about that a long time ago. And then they're saying that in this one. I just don't see how landing on grass, you're able to get a good footprint. I don't know. Because you have the grass there that would sort of alter a nice print. But, there is dirt below it, but the grass is thick there. I've been there. I even looked at that exact thing, like, man, how would that even happen? Let's see. It says, yes, you can get ChatGPT, or not Chat, the Google one says, yes, you can get an excellent footprint when landing on grass, provided the surface is dry, firm, and well-maintained grass. Grass provided, how about, okay, not print, though. I'm looking for, can you get a good shoe print? That's really what we're looking at. Because, yes, you can make an indentation. Okay. Now, see how I altered it? Listen to what it says now. It is difficult to get a highly detailed shoe brand print on standard healthy grass, though you can often identify the shoe type or tread pattern. So maybe they're able to find a little bit of something in there. Okay, so that is whatever you guys were saying earlier. You super sleuthy people. No, they didn't. There's no UV lights you don't use when you're just using a footprint like that. That's when there's blood or, some kind of something interacting that you spray on there. Mm-hmm. And if there's somebody out there that was been watching Candace is now saying that the person's way over 6'1". Okay, so I can tell you right now, I'll have to make a debunking video on it because I've been there. I have footage in there, and yeah, this one right here actually. So look at, see this line right there? That's the only line on the wall, and I'm taller than it, and I am. So even if I had walked forward, my head would be, I'm actually bent over there. My head would be right at the same level of those upper dots. You see that? Like even if I walked forward, because I'm right next to the wall there. So my head would be right next to these dots right there, and there's only one line there. So when we go to the video that just came out of Tyler coming in on this is the one that matters. Now look at the camera is high up in the air. The wall actually goes up into there, right? Because there's the line. There isn't another line in there. So that means it's being blocked, like you can't see the upper portion of it. So here he comes. Well, I'm not sure if I said way. I meant to say high. So look at right here. See this right here? So see when he's coming in, his head is... it's crazy because my head is above that line, right? Yeah, look at that. So he's short, Tyler is. He seems like he's like 5'8" or something. It's weird. Either that or I'm a giant. I definitely had a couple pieces of pizza, though, I can tell you that. But look. See how his head is not even above that, and if we go back, see right there, he's right next to the wall, right there, as close as I was, and his head is not above it. And right there, he's going away from it a little bit, but I don't know, man. He seems shorter. I think he's like 5'8". Yeah, it said 5'10" on it. Maybe they had his shoes on, though. You fixate on details that don't matter, and her brain-dead fans think it's the greatest revelation. But she's totally ignored Tyler. She fixates on details that don't matter. Well, she just finds something that she thinks can help her story. I thought you said I fixate on things. Yeah. I just try to find every little piece of information and get an exact, like if I don't know the answer to something, I try to figure out a way to get the precise answer. That's why we have 12, 23, 28 already. That's why we have the 10:07 to 10:08 time frame. We know that because that's how long it takes to walk there. So it's like 10:07, 10:08 when he walks by that house. It's just, man, I wish that somehow my channel was known about by more of these people because there'd be a lot less dumb people out there. That's just true. That's a fact. It sucks. I've literally, like, if you've been following my channel right now, everything you're hearing right now would be, shit, that's what we thought. Because that's what I've been saying. Yeah, I don't know. That's what I'm saying. I don't know how they get a tread in grass, even if you jump down and, there's dirt obviously underneath it, but to get the sole to then go through the grass and make an impression, and then, I don't know, it seems like that'd be hard. But maybe they have a way to do it. And here's the thing, you guys. The shoe print is meaningless. It's absolutely meaningless. You already have a screwdriver on the roof that has his DNA on it. And I think they have his DNA when he dragged his hand off of there. At least you would hope they would. And it proves that he was on the roof. And his parents identified him as the guy walking with the limp. You can see the limp in all the videos. It's crazy. Yeah, Candace Owens, literally, it's a cult over there. That's a fact. Jack, I know what movie that's from. It's from Stripes with Bill Murray. Maybe that's in more movies than just that. Yeah, I don't know if that's where it was invented, but I always like that movie just to watch the scene where they all come out and do their, the gun twirling, whatever you want it, marching, I guess. Yeah, well, it doesn't seem right, 5'10", because I'm way taller than that. Look, see that? My shoulder is at that line. I'm actually having to bend over a little bit. Now look at his look at him. His shoulder is way below that line, and he's standing next to the wall. I don't know. I mean, he's really close to the wall right there. I don't know. He doesn't seem that tall. I mean, his head is, I guess, like that is where he's standing straight up there. And so, maybe, like, if you slid him over, his head would be right on the line, perhaps. I don't know. And I'm only 5'11", so... I bet his parents were in court today saying, oh, shit, that's our kid. Now, we're not just looking at photographs. We're seeing him walk. They know it's him when they're looking at him. That would be interesting, right? Like, look at his parents, are just probably their heads are down, like, oh, shit. Oh, boy, that's our boy. Yeah. Candace will say, they told me it wasn't. Well, what are they supposed to say? Okay. Yeah, we know. Yeah, we know that, Grinch. We've seen it 1,000 times where he's stepping down with the leg. It's interesting too because we haven't really seen. We've just seen him walking on the street, and you can see he's always limping with his right leg stiffer. So. All I could do is picture him going down the stairs, and it's exactly how I pictured it in my head. How about you guys? That's right, that one. What do you mean he's leaning away from the wall? I don't know what you're talking about. He's a little bit away from it, not far though. And look at his right shoulder. I mean, even if he's leaning, that means he's making his right shoulder even higher, right? So he's leaning with his left, if you want to say that. That means his right shoulder would even be higher there. But look at it. I mean, I'm talking about like when I'm there, I'm like, wait, if I walked right over there, my shoulder would be right here, and my head, if I stood up straight, would be above these dots here. Okay? He seems kind of little. And I'm standing about the same distance away as he is. See that? I'm not right next to the wall there. So you look at his.
We're still with Mr. Burt and Ms. Baker. Direct examination.
He's the same distance about right there. See that? It's crazy. He's a little bit shorter than I am.
Would you take a look at, in your notes, page 24 of 379?
So I don't agree. Jeez, I've been there, you guys. Raider, I've been there. I don't need
At the very bottom of the page.
Yeah, slope down, blah, 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 blah. I got it.
Did you write there on the 15th of September 2025, spoke with Special Agent Folger, gave update on report timeline discuss it upon review, it was decided that additional statistics needed to be run. Report will still be issued with Twigs as an assumed contributor per previous discussions with Folger and Carmack. You see that?
Yes, I do.
And what additional statistics needed to be run at that time?
So at that time, I believe I ran statistics with just Twigs comparing that individual to the sample. If I may refer, I think that was the only additional.
The magistrate just say, listen, you're not going to change my mind. It looks pretty good for the DNA. All right, move on to the next topic.
Yes, after discussion with my reviewer, it was determined that I was also going to calculate a statistic or compare Twigs by himself, comparing him to the evidence, and having that run in my case file.
Okay. And could you go to tab 38, page 39?
Oh.
Yeah, it should not be on the screen.
Let's pull it down from the screen. Thank you.
Thank
So
you.
just to the monitors of the attorneys and the witness, Mr. Burt?
Just for the witness, Your Honor.
Okay, just for the witness.
39. And this is page 39. Is this the DNA report, I'm sorry, the star mix report that was produced as a result of your inquiry that involved a comparison of the sample to Mr. Twigs alone?
Yes, it is.
And is that a 6-page report?
Yes, it is.
And is it a true and accurate copy of the STR mix report for that particular sample?
Yes, it is.
I'd move that into evidence, Your Honor. This would be Baker 38, page 39 through 44.
Baker 38, page 39 through,
I'm seeking admission as well as publication to the audience and the camera.
I just want to make sure I have the label correct. Baker 38, pages 39 through 44. Did I hear that correctly?
That's correct, Your Honor.
All right. To the state?
Yes, Your Honor, I object on grounds of relevance to the probable cause determination.
All right. And Mr. Burt, would you like to respond?
Submitted, Your Honor.
So I'm not exactly sure what this is in order to
Sure.
determine how it fits into the probable cause analysis.
Sure.
So a little bit more information, because as of right now, I don't have enough to admit it.
Understood, and I apologize to the court. So the report that was admitted into evidence has the conclusion in it that both samples were contributed, that Mr. Twigs was a contributor to both samples. And this is the report that the analyst ran in order to make that determination, I believe.
All right. Did these reports, were these made prior to State's Exhibit 31 being prepared?
Yes, that's correct.
All right. I will admit, so Baker 38, pages 39 through 44 is admitted and may be published. Again, as a reminder, for all attorneys, this is a probable cause standard, so if all parties can just keep that in mind as we're moving forward on this.
Sure.
Thank you.
Thank you.
And so it
He's
may
really
be
saying is
published
you're
to
not
all
following
screens.
it.
Yeah, it's page.
What? What's going on? What happened?
So is this the report that you referenced in your notes that you needed to run the sample through StarMix?
Yes.
Now,
You mix it through Starlink?
At the
Wow,
top.
through satellites.
this is the StarMix
Oh.
unit dated September 15th, and it relates to item 7-1, correct?
That is correct, yes.
Listen, you're not onto
Right.
something, attorney.
And then down below
You're not
that,
onto something.
the kit used, if you could go to the summary of the input. You tell the software program, assume there are 2 contributors, right?
Correct, yes.
You input
Oh my God.
sample 7A,
She said correct.
Correct, yes.
and when you input it, it's just the raw data, right?
Correct, just the numbers from the graph.
The numbers, and then known contributors under HP, the prosecution hypothesis.
Correct, yes.
And you put in sample 61,
Yes.
right? That's Twiggs's known sample.
Correct, yes.
And then the known contributors under the defense hypothesis, you left that blank.
Correct.
Is that because you didn't know what the defense hypothesis was?
No, again, the defense hypothesis for this situation, if I'm comparing someone, is an unknown, unrelated individual, and that is taken into account during the calculation.
Okay. And then you input that data, and what you get out from that
Is a likelihood ratio, right?
Correct, yes.
So let's go to page 2 of that report. Correct. Is this a summary of the
results from that test on the 15th in terms of
That's
a
crazy.
likelihood ratio?
Yes, it is.
What is a likelihood ratio? What does that mean?
A likelihood ratio is a statistic that calculates the probability of seeing a DNA profile given one of 2 different hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. The probability with the higher number gets the support,
and the magnitude of the support is determined by the ratio of those 2 numbers.
That's pretty technical stuff, but the bottom line is,
is that the software computes the numbers, and then you look at those numbers and determine
whether it has any significance, right?
I don't know that I would say if it has significance. I report the value that's calculated.
Right, and why is one column, these columns relate to different, what are called population databases, right?
That is correct, yes.
One on the far left, BAH, is an FBI population database on Bahamas.
And African Americans, yes.
African Americans.
Another one for Caucasians. Correct, yes.
SEH is Southeast Hispanics,
correct?
and then Southwest Hispanics.
Objection.
That's all I have on that. I'm just trying to explain the chart.
What the hell is this?
Pause and turning to Mr. McBride.
Sure.
Your Honor, at this point, I'm going to object on, again, grounds of relevance to probable cause hearing. State v. Drosbeck, State v. Merrill, State v. Ramirez that the court has cited, all hold that the court should bind the defendant over for trial unless the evidence is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. I don't know that any of this analysis goes to whether or not the expert's testimony and her report is wholly lacking and incapable of reasonable inference to prove her result in this case. We're far beyond this. We're hours into this examination. This feels like a 702 hearing to me. I think we're far beyond a probable cause hearing, Your Honor. I would ask the court to sustain the objection, not allow questioning on this or any other matter that does not deal with the issue of probable cause.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, the state offered this report on a very technical, complex, scientific area of inquiry. And they offered to the court a conclusion in that report that Mr. Robinson and Mr. Twiggs were contributors to 2 samples that were found at the crime scene. They obviously think that's relevant to the probable cause inquiry, or they wouldn't have offered the report in the first place. So having done that, I think the defense is entitled to inquire whether those conclusions are reliable, because that, again, is the court's ultimate.
The judge needs to take
determination,
control of his courtroom
reliability
here.
of
He's
this
really
evidence.
being
And the court
ludicrous
can
at this
decide
point, honest to God.
it's not relevant, I'm sorry, it's not reliable.
No, you're right the
We're not
first
gonna
time. It's
rely
not
on
relevant. Let's play that
in
back.
Determining probable cause. And that, or the court could say it is reliable, and it bolsters up other evidence that the court is going to hear from. So the particular report in front of us goes directly to the issue of whether the expert correctly
Yeah, the judge
concluded
is he's kind of lost
that
control of this
Twiggs
guy here.
not was a
This guy's an
possible
idiot.
contributor, but was a contributor. And the state's theory here apparently is that both Mr. Robinson
I don't know if he's an
and Mr.
idiot, but
Twiggs
he's just,
are somehow connected to this.
he's like one of those guys that are just
So
talking for the
I
sake of
think
talking.
When the court sees
You know, like we all do.
what the numbers were generated and how that compares to her own standards for assessment, the court will see that the conclusion is not just.
10, 20, 25, 30, hit that like button, 4, 5, hit that like button. It's the easiest damn thing to do in the world. Hit that like button, 10, 20, 25, 30, hit that like. I mean, hell, that's better, right? If it was a little quicker.
The issue is whether we walk 1 mile or 100 miles down the path, and so I want to keep it limited to 1 mile.
But you've already got
as opposed to
25,
100 miles,
Judge.
because
You've already
that
got
would
25,
exceed the
Judge.
Probable cause standard for.
You're not at the
preliminary
mile.
Hearing for what is before me. And so, Mr. Burt,
This
as
guy
it
almost
relates to the.
feels shame. Look how he doesn't
objection,
look at the judge while he's
I'm going
talking.
to sustain it in part. If you want to briefly address it
Ah!
and move on.
There's no briefly here, man.
you
There's no
certainly may
briefly.
choose to do so, but.
There's no briefly at all, everybody.
relates
Again, let's
to,
go back to that picture I showed you earlier.
Where we're at.
We are going to look like
My
this.
hope is we can keep
when
this
that guy's
very
done
brief as
Yes.
with
opposed to
his
going through all
brief
this,
comment,
so we can move
okay?
on to whatever else.
Now, you
would
pick
like to
whichever one
present.
in there you want to look like,
We'll do that
okay? We
right
are
now.
absolutely,
In the interest of doing that, could you bring up on the same screen part of her report, People's Exhibit 31?
oh, good God, oh, good
Let's take
God,
that
here we go, oh, Jesus.
off.
Oh, I'm going to need that up there because I need to do
Oh,
it.
so is it part of the same? It was on the screen. I want to make sure that what you're calling up on the screen right now,
Maybe I
is
should-
it
maybe
part of
a
this
good way-
that was already admitted or something else?
It's part of this, which has already been admitted, compared to.
Don't you love that song, by the way?
Or Plaintiff's Exhibit 31. which
Are you
is
angry
also
at me?
admitted.
Okay,
So
thank
they're
you.
both
I
in.
just wanted to.
Remember that from Jody Arias?
All right.
Are you
so,
angry at me?
If you, and do you want that published on this, all
Yes.
screens? All right, let's go ahead and do so.
Breaking up is hard to do.
And the chart I read from that report is on
Cadabra.
page 5.
I like Steve Miller's greatest hits, man. That's good shit. I like that one. Let's see.
Yeah, just highlight that. Thank you.
Wow, man, I forgot the name of it. Jeez.
So what we've blown up there is from your report, Plaintiff's 31, and you provided this chart in the report, correct?
That is correct.
My
yes.
favorite
Explain
song
to
that
the
he
court how
does
this
is,
works, what this chart is supposed to
for
represent.
some reason I
Sure.
can't remember the
So
name.
this is our
It's crazy.
verbal scale.
I know.
In addition to the numerical likelihood ratio value that I
Serenade.
provide,
Love
I also
Serenade,
give a
that song.
qualitative or a verbal equivalent to that numerical value. That gives some kind of context to
Yeah,
what that
listen to
likelihood
Serenade
ratio
by
means.
Steve Miller. That's a good one.
Okay, and on the left, explain what the greater than 1 million.
Well, greater than 1
less
million
than
means 1 million
means.
and 1.
What does that
Okay, sir?
scale
Thank you very
relate
much.
Sure. So that scale is the numerical value of the likelihood ratio. So if I have a likelihood ratio that's greater than or equal to 1 million, I designate that as very strong support for inclusion. The next example, 10,000 to less than 1 million, I would say that's very strong support for inclusion, and so forth.
So you need to reach a likelihood ratio of 2 in order to get even limited support for an inclusion, correct?
Correct, yes.
Okay, if you could not reduce that,
Oh, good Lord, man. This guy. He's.
and go to page 2 of the report on the left.
I thought I turned it off, so it made me laugh when it came on again.
So from this chart, when you ran Mr. Twiggs against the sample, what was the likelihood ratio that you determined?
I believe this chart is not the comparison to Mr. Twiggs.
That's not in the report?
The chart at the bottom of the screen is not my comparison to Mr. Twiggs.
I like
Let's
tequila.
verify that if we could.
Good
Take
for you,
that down.
Phyllis.
The
Tequila feels a little different, you know what I mean? When you have a shot of tequila, you have it's a little different buzz than a beer or a glass of
And
wine.
repost 38, page 45. I'm sorry.
Yes, you see the counter process not only correlates to the factors present here, but when we
Page 39,
utilize
that
not
is
only
in
the
evidence.
sequential facts of the non-sequential elements of the lesser contributor, we come up with a figure that
Is
only
this
looks
the
something
likelihood
like
ratio
that's how this
from
person
your
talks.
Twiggs
There's no meaning
Yes,
at all of
yes.
anything.
Okay. Now, what was the
That's 'cause you
likelihood
don't
ratio that you
understand, Gray.
calculated based on this chart?
The likelihood ratio was 1.
1.
Yes.
So that doesn't rise to the level of even limited inclusion, correct?
Correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twiggs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr.
Oops.
Twiggs was a possible contributor, or that I could use him as an assumed contributor. I visually looked at the DNA sample, and the DNA, unlike that major contributor, he also had those peaks. So that was one proposition or one hypothesis that I determined that he was an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twiggs as an elimination.
Let me see if I understand that. The STR mix that you relied upon to include Mr. you relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twiggs's sample through STR mix, the result you got was...
Get out of here! Come on, move on!
Or that it was of not even of limited value in including him.
Based on the star mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay.
Should I play the We're a Freak song instead?
Is there some standard that you use for deciding when not to rely on the star mix results? And when to sort of disregard it and rely on
I don't know. I'm just
your
getting this
training
is just
and experience?
it's not needed. None of this
I
stuff.
can't say that I disregarded it. When I'm
trial
comparing
is
someone,
important,
that's my
but,
first
not here.
determination. Do I think this person is potentially included or excluded? If I determine that I think they're included, I will run star mix to give weight to that inclusion. Elimination samples are different. If I'm told that an individual is submitted as an elimination sample, I can assume they're there. Visually, I'm able to look at the DNA evidence
Right.
and determine, yes, I think there's enough evidence there to assume that individual, which is what I did here.
Okay. At D16, Mr. Twiggs was a 912, right? According to your electropherograms?
Yeah, that's right. He didn't do it, man. Again, you guys, the Tyler Robinson case is the strongest
That is
case
correct,
I've
yes.
ever
Mr.
seen.
Twiggs was a 912 at D16.
And I've seen a lot.
And did you find 912 at that location in the 8-1 sample?
I'm sorry, the sample 8 or sample 7?
Sample 8.
Maybe this will make it more interesting. Let's see. On a cold, windy night, the juror was asked a question. He didn't answer.
The only piece of information I had for sample 8 at item D16 was a 12.
My
And
God,
said
did
Twiggs
you
at
hear
that?
that?
Was a 912, right?
Correct,
Only a
yes.
12.
But at that location, the evidence sample was not a 912, but a 12.
This is incredible.
That was the only piece of information that was recovered at that location.
Let me ask you about your interpretation rules for excluding someone. Is this an accurate statement? This is from Butler's
That's right.
textbook. In forensic DNA analysis, if any STR locus fails to match when comparing the genotypes between 2 or more samples, then the comparison of profiles between the question and the reference sample is usually declared a non-match, regardless of how many other loci match.
I would agree with that if it's a single source sample. So single source, again, meaning from one individual. If I have a DNA profile from evidence and I compare it to a known individual, if there's a difference at even one location, I can say it's an exclusion. If I have a mixture, it's not that cut and dry. I have to take into account how many people are in that mixture, how many pieces of information
screwdriver
I
and
have,
towel.
is there potential
It's like
dropout?
it's a huge part of the case.
So it's just
It puts
because
them on the
someone may
roof.
not be present in a mixture doesn't necessarily mean that I'm going to
Screwdriver
automatically exclude
places
them.
them on the roof.
I see.
The towel is
At D19S,
incredible
what
circumstantial
was
evidence
Mr.
because there's a guy carrying a
Twiggs's
towel and the
type?
gun. It was wrapped around the gun. The gun had his DNA on it. Tyler Robbins' DNA, I think, is even going to be on the ledge there when he had his fingers.
He was a
and dropped
14,
off.
16.
Did you find a 16 allele in the 8A sample?
No, I did not.
Okay. At Tho, what was Mr. Twiggs's type?
He was a 7, 9.3.
Did you find a 7 allele in the 8-1 sample?
No, I did not. But again, this is a mixture and there is some dropout. So just because I didn't see a 7, for example, does not mean I would automatically exclude someone.
It's a mixture, so there was some dropout. So did you assume that at that location that the allele that dropped out matched his allele?
At that location, no, there's only one individual represented there. So when comparing an elimination, I would essentially ignore that location. I'm looking at the other locations where there was 2
Okay,
individuals
we've heard
present.
enough from you, sir. Thank you very much.
couple
All
more
right, thank you.
topics and then we're
Oh, a
done.
couple more thoughts.
When you received this,
They're coming to take me away.
you got more than 7 and 8, correct? You got a number of other samples.
Don't you guys feel like
Correct, I
that right now?
A backpack, which you labeled as Exhibit 9, and a bunch of items from that backpack. Correct?
Correct, yes.
You were initially told that those items related to things that may have been discarded by the suspect.
So initially, we didn't have any information. So we processed that. Those are items that are good for DNA, not having any
Alert
information.
everybody, alert
from
everybody.
investigators,
The
we
Egyptian
processed that
plane
DNA.
dropped the
As
alleles.
the investigation continues.
Did you hear what I
we
said? They
determined
dropped the
that
alleles.
backpack,
Ask Phyllis
was
Watson. She'll let you
potentially left
know.
behind by a bystander, and there was no comparisons needed at that time.
Well,
When the Egyptian plane flew over Orem, Utah, it dropped a bucket full of alleles onto the roofs. Which alleles survived? Find out later at 7 when we hear the DNA expert talk. Thank you very much.
Yes, based on the individual that was not my communication log, that was someone else within the laboratory. That was the information that they received.
before you received any samples, did you request to perform what's called destructive testing on the samples?
Yes, I did. And destructive testing is essentially consuming the sample.
You know, it'd be cool is to listen to this
cutting the
testimony with
cotton off of
Dr.
the
Colleen
Q-tip or the
Fitzpatrick.
swab, subjecting it to
She
testing.
would shred this
There's
guy.
nothing, so there's nothing remaining. I have to request permission to consume prior to doing so, and I did in this case.
And why did you do that?
That is part of our protocols, that we have to request permission to consume, and we consume, so DNA, we can't see it, so when an item is swabbed, we don't know how much DNA is on that swab, if anything, or how that swab was used. Did someone just swab using one side of it? Did they roll it and use all sides? Because I don't know that, it's our practice to consume that swab. It's our best chance of getting any DNA evidence.
And that's a determination that you made in this case before you even saw any of the evidence, correct?
Determination to consume?
Yeah.
Yes.
Okay. Now, remember I referred to that NRC report?
I had to go.
Yes.
96. Did they say there a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated? Such an opportunity should be provided whenever possible.
Yes, it does say that.
And does your laboratory have
Samples?
a policy, standard 7.4, which says, where possible, the laboratory shall retain or return a portion of the
Yeah, I've got
evidence,
half the
sample,
people
or
watching that were watching earlier.
That is correct. And we do
Because this is
actually
bullshit.
return the remaining extract, the liquid from our DNA testing. So we did consume the swab. However, there was a small amount of liquid that was left and returned.
on some of the items, right?
I believe on all of the items.
Well, we'll get to that in a minute. And that policy that I read is from your lab policy, right? The
Yes.
FBI's lab policy.
Yes, it is.
And then, is there also a similar policy from the quality assurance standards, the FBI quality assurance standards, which says the laboratory must have a policy on sample consumption? The policy is expected to provide instruction for if and when the laboratory may or may not consume a sample, and any documentation that the laboratory requires.
That is correct, yes.
Okay. Now, your report indicates that certain samples were destroyed, consumed, correct?
That is correct, yes.
And which samples were consumed?
Items 1 through 6, which were swabs from possible smudge, swabs of hand swipe, swabs from possible sweat drop, swabs from possible smudge, swabs of possible smudge, and swabs from possible sweat drop. In addition to items 54 and 55, which were swabs of swiped finger areas and swabs of stairwell railing.
Okay, so when you wrote in your report that those items were consumed, which of those items, and by that you mean the actual swab was consumed?
Correct. So a swab is just like a Q-tip. So the cotton portion of that swab was cut off the wooden stick, placed into a tube, subjected to DNA testing. So we consider that consuming. But again, there is liquid at the end of the process that is returned to the field.
And the normal procedure in terms of sample preservation would be something called sample splitting, right? You split the swab and you use half, you save half so that your testing results can be replicated and retested.
So yes, however, again, I don't know how an item is swabbed. So even if I were to cut that swab in half, it could be that I'm testing the half that doesn't have any DNA and the other half may have some DNA. Or the swab may have a little bit of DNA on one side and a lot on the other side. So for the best possible chance of getting a DNA profile, it is our practice to consume the entire swab.
So for the first 6 items, those were swabs that were taken from the northeast corner of the Losi building, correct?
Correct, yes.
And you used all of the swabs, and you concluded that there was no DNA present on any of those items, correct?
That is correct.
So you couldn't do any comparative testing?
Correct. There was nothing for me to compare to.
Okay, and what did you have left after you did that in terms of the volume of extract? What was left?
So it was approximately 3 microliters, so a very small portion.
Very small portion, and you actually used 10 microliters to do your testing of those samples, right?
That is correct, yes.
So if you didn't get any results with 10, what you left over would not be sufficient to get any sort of independent testing done, correct?
It could be tested, however, my expectation, if I took 10 microliters and did not get any DNA, the remaining 3 would also still not give me any DNA.
Okay. And for item 55, that was 2 swabs of a stairwell, from a stairwell railing where the suspect touched the railing, right?
As far as I know, they were swabs from a stairwell.
And correct me if I'm wrong, but I understand from your lab notes that you took those 2 swabs and combined them into one sample and then used the whole sample, right?
That is correct, yes.
Okay. Before you did that, did you inquire whether the 2 swabs came from 2 different areas? For instance, maybe the suspect touched it.
Wow, hey, thanks, Wild Bill
The other
Watson.
sample was taken
It's been about an
somewhere
hour since the
I
last,
did not. They were both
anything,
labeled
but
as
thank
coming
you.
from the same stairwell, and they were packaged together. So our policies and procedures is that we can combine those 2 together.
And when you do that, you create a mixture, right?
I don't know that I would agree that combining the 2 would create a mixture. Given the item of evidence, a stairwell railing, I don't necessarily expect that one swab would have one person, the second swab would have a different second person, and combining the 2 of them creates a mixture. However, I don't know that for certain, but again, I don't know is DNA present, so our procedure is to combine and consume those swabs.
And grits for brains
In this
here
case, when you
shoots him.
that,
Did you hear what
got
I
was
said?
a complex mixture, right?
I did. I got DNA from more than 5 individuals, so I could not provide a conclusion.
All right? Now,
Mr. Burt, and we are at the 4:30 point. I just want to inquire, with not
I just
applying
have
pressure,
one
just trying to
area left.
understand. Okay.
no, be done with it.
Yeah, oh, you'll be done with it, yeah.
We
You're
talked
garbage.
earlier about
Okay,
your
bye.
testing of the length of the DNA sequence, the length of the DNA boxcars,
Holy crap,
not
are you
the
kidding me?
sequence of A, C, T, and G within
You've got
those
to be joking,
sequences,
you guys.
within those boxcars, right?
He's gonna
Correct,
do it
yes.
again.
And is it true
This is
that
insane.
there are different alleles that have the same length when you measure by SDRs, but have different sequences?
Yes, that is possible.
And I'd like to show you a chart that you have reviewed, I believe. This is, could you bring it up? 34. This is not in front of on the public screen, just for the witness. And is this a chart that you reviewed, that I prepared, you look at and see if I correctly stated?
Yes, it is.
Does it, as it's presently existing, accurately state what the units are in each location?
Yes.
Chasing every clue, like
I would move that into evidence. It's 5 pages.
It's the twist, the turns, the secrets they keep. Falling down rabbit holes, it's a crime to sleep. I'm a freak, yeah, I'm a freak. Got a curious mind, and I dive in deep. I'm a freak, yeah,
And this exhibit in the next one,
but I'm not alone.
the comparisons between
There's millions just like me.
evidence that are usable and reliable.
Lumen hole on crime scene.
I'm not sure I'm following what you're saying on there, right? Maybe it's just because it's
Silence
late in the
screams
day.
through
Yeah.
empty halls.
So this chart.
Yeah, somebody made this for me a long time, like 6 months ago.
I'm a freak. Yeah, I'm a freak. Got a curious mind.
The other one is
Diving deep. I'm a freak. Yeah, I'm a freak. But I'm not alone. There's millions just like me. There's a whole world of people who
first
think
reading there is
like
for Tyler
me.
Robinson at the B3.
Yeah, I'm a
location.
freak and I'm
17.
proud to be.
I don't use it.
Call us strange, call us obsessed,
Report introduced by the state.
but
You'll
we're
see
just
that sheet
curious
has 17
minds
there as well.
doing what we do
Measured only by the
best.
length.
It's not the danger, it's a story
What she's going to
beneath.
testify to is that
The
this
hunt for the
location,
answer
5 or 6 others,
that makes us
there
the
are
free.
appeals, all of which measure here 17, but actually contain missing pieces. And that her testimony
I don't care, Cindy. He's saying, can you get done with this crap, please? That's the end of it anyway.
Trial, this may be a little bit different analysis that they.
Yeah, he's saying, like, the judge is pissed off. Look at his face.
But as a magistrate, taking a look at this and looking at the probable cause standard.
That was the
how-
end of it anyway.
How does this comport?
I don't
So it
really give a
comports
shit
because
though,
it
what they're
goes to
being,
the
what's being
ultimate
said here.
opinion expressed in the report that
Stupid.
the state is
The
offering.
whole thing, this shouldn't be talked
that
about.
The
It's a waste of
report
time.
offers reliable support that Mr. Robinson is a possible.
The judge, you know what he's doing? He's
We're
having
asking the
visions
court to
of the
consider
trial.
that
He can see what's going to
the
happen.
Comparisons are only based on a limited number of
Cindy's all, you're always a
length-based
buzzkill.
comparisons,
Yeah, just
and that
let it
there
go.
are
You know, you don't need
sequence
to.
differences so
I don't
that
give
she
a
cannot
shit what he's
distinguish.
talking about right now.
And I believe she'll testify, she cannot distinguish, based on the testing that she did, in at least 5 separate locations, whether the evidence sample and Mr. Robinson's sample, or for that matter, Mr. Twig's sample, matches the sequence differences here. And this is my final area, and I think I can do it very efficiently, and I think it is important for the court to consider, especially as it relates to the comparison to Mr. Robinson.
Nah.
Mr. McBride.
And she is also going to testify that the
The
analysis she
judge-
does
the
is based
judge.
on
God,
looking at the totality and all of the different markers that match.
Oh, maybe he did a little
and are
bit, Cindy.
consistent.
But
And
come on.
That's how she
Just
comes
let
to
the song play
opinion
out.
that
It
she
was almost
does.
done,
The point
okay.
is, there are explanations that are susceptible to different interpretations and arguments. Ultimately, we're going to have an expert
I was
hearing
getting
where
into
all
the
of
song.
literature is going to be before the court, and the court's going to determine if it meets the threshold of reliability.
No, it's
for
not. It's
admission
not
to
making
trial.
it going
But at this
down. It's
stage,
going down because
even-
nobody wants to hear
even
DNA talk.
Granting that there may be some
Okay, idiot.
argument that may come from defense counsel's position, the court can't wait.
Don't ever come in
This
here
does
and
not
tell
go
me to
probable cause
chill again,
determination.
or I'll remove you.
And I don't think it's relevant, and this exhibit in particular is not relevant without the testimony of the witness, and so the exhibit should not be admitted on its face either.
That's why I was trying to lay a foundation that she would, and offered a proof to the court that she would testify, that in fact there are these sequence differences at the 5 or 6 locations, 6 different locations, relevant to the comparison to Mr. Robinson.
Well,
And
that's not why people,
when
it was down to 110
the state
with
says
no
the court
music.
cannot weigh it, the court
Okay.
can weigh
People are,
reliability.
it's just boring
The court
as
has ruled
shit.
that. So
This guy's doing it on
We're
purpose.
simply asking the court to
It's
take into
garbage.
account the limited nature of these
Even this right
comparisons
here
and the
is
fact that
mind-boggling.
She cannot,
This
based on the
explanation.
testing that she performed, tell the court whether.
If I was a judge right now, I'd go,
there
listen,
are differences
I'm not going to have any more of
between,
this crap right here, okay?
at these
And if you
5
act like this at
locations,
trial, I'm going to sanction you,
She can't
the
match
defense team.
Mr. Robinson to the question samples because she didn't do sequence testing. And she'll also
Garbage.
testify that the FBI is in the process of implementing this kind of testing.
All right. Thank you to both
It's
sides.
okay, Robin the Hood. Just don't
I'm
tell
gonna
me what to
admit,
do and stuff like
allow
that.
the admission
yeah.
of this evidence, but I'm also going to set a limit of a limited number of questions. We are now at 4:40. This is on the cusp of whether it is
Lunacy.
applicable to the probable cause standard. I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into a full exploration, because that's not the purpose of a preliminary hearing. So I will admit Baker 34, but Mr. Burt, I'm going to limit you to how much time do you need to address
I just
this?
need about 4 or 5 minutes. I'm going to, the next chart will be the chart with the, what are called ISO.
Hey, put a 1 if you think it's going to be 5 minutes here.
We're talking about, and that's it.
All right.
I'm just
Yeah,
gonna
put a 1 if you think
have
this
to
is 5 minutes.
Document that, in fact, I've accurately stated what the alleles are that have sequence differences.
All right, so it is Mr. McBride.
Just on a second matter, which is, I need to cross-examine this witness. She's got to leave town today. I would like 20 minutes to cross-examine the witness.
All right, well, I will go with the, I accept Mr. Burt's representations in the amount of time, and I'm going to talk less because that's consuming more time, and also allow the state the appropriate time for cross-examination, given the nature of this witness having to travel. So, Mr. Burt, I'll turn to you. This has been moved into evidence. Do you want it on the screens?
Actually, I don't need it on the screen, just
Man,
in the interest.
imagine having a
of
beer with this
efficiency. Pull up
defense
the next
attorney.
one, please.
Okay.
Good Lord, man. Now we got another 20 minutes after that. I don't even know if I can do this. I just want to go do my walk.
35. Take that one down. And is this exhibit the same chart with what are called the isoalleles indicated?
Yes, it is.
And isoalleles is a term used to refer to these alleles that have
Okay, it's
different sequence. with the same
339
length.
here.
Correct, yes.
So across the top
Yeah,
there
hold on,
for allele 17 and D3, there is a allele 17A, allele 17B, allele 17C, all with the same length, but different sequences for each of those three.
Correct, yes.
And similarly at
Add about 30
VWA,
seconds to that.
where you say that Mr. Robinson is an 1819 and 1819 in the evidence sample, there's an 18A, a 18B, a 19A, and a 19B.
Correct, yes.
And similarly for the other areas I've indicated there, I've accurately stated what the different sequence alleles are, correct?
Yes.
So I move this exhibit into evidence, Your Honor, and for publication.
Is this Baker 34?
Yes. 30, 35. Baker 35.
Same objection, Your Honor.
All right, I'll admit it into evidence under the previous statement as it relates to Baker 34. It may be published.
35? Ah, God. This is painful. Like, you can even tell the judge is pissed off, but he's trying to give
And
the
as you look at
defense
these
as
five
much
areas, you can't
latitude
distinguish
as
the
possible.
evidence samples from Mr. Robinson based on the sequence differences, can you?
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
Right. What is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
Right. But the people who market STR Mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
This is about 30 seconds. My clock's going to be
Last
40
question,
seconds
take a look
behind.
at.
So it's really 240, 250. Last question we're going to look at. Now he says last question to look at. You got to be kidding me. As he slowly digs through the paperwork, trying to find what the hell he's going to talk about next.
Well, I'll save that for redirect. Thank you.
Redirect? Who's doing a redirect?
Turning to
Wow, he got out of there less than 3 minutes because he couldn't find his file. Imagine if he had found that file. We'd be sitting here next month. So he got lucky there. He just couldn't find the thing he was looking for. I'll save that for redirect. Ah. That's great.
Oops.
Ah, Jesus. Now we got to pick up the papers. Read this whole thing now.
Good afternoon.
Good afternoon.
Look at the judge.
I want to start by asking
The judge
you,
has no patience right now.
what your training and experience is.
He's
First
just
of all, do you have any education?
He's looking at
Yes,
everybody
I do.
like,
I have a bachelor's of science in
Why are you so
biology
slow?
from Salisbury University.
And do you, after your bachelor's in biology degree, what did you do for your career and in further
I
education?
thought this was,
Upon graduating from college,
prosecution
I began
witness.
working at the FBI laboratory
Haven't
as
they already done
a
this?
contractor. I was assigned to
I don't
the
get it.
Federal Convicted Offender Program, which was a program under the DNA unit. During that time, I did that for approximately a year and a half. It was my responsibility to open and inventory and barcode DNA collection kits sent in from federal agencies across the United States. I then became a biologist in the DNA casework unit. I did that for approximately 6 years.
How come they're
During
asking
that
these
time,
questions
I did the
now?
actual testing of
I don't get
items
it.
of evidence, so swabbing, cutting those swabs.
thought this is
producing
cross
the DNA
here.
profile. And then in
No, this is
2015,
cross right
I
here.
accepted a position as a
that
forensic
was their
examiner,
witness?
which I am still today.
God, she wasn't
sorry,
very
what
good
year
for
was
her.
that?
Yeah.
2015.
So 11 years you've
This
been
is
doing more or less the same
cross-examination.
duties you have now, is that right?
Correct, yes.
I want to ask you about your lab's accreditation. What is accreditation for a laboratory?
Hey, hold on one second. Let me go
Accreditation
look at
is a formal recognition that our laboratory is following a very strict set of standards. We're accredited by ANAB, the American National Standards Institute, National Accreditation.
What do you do for a living?
I am a forensic examiner in the DNA casework unit
See, look
of
at
the
that. Why are they doing
FBI
it again?
laboratory located in Quantico, Virginia.
That's weird.
And how long have you been a DNA?
Accreditation board.
See, they were the ones
And our
that were the defense witness.
accreditation shows that I have or we have to follow standards such as I have to have a certain education background,
Weird.
how we process evidence, how we store evidence. Every
This right
4
here is
years,
cross
we're
right here.
audited
Nose
to
is
those
cross.
standards, meaning an outside body will come into our laboratory, look at my training records, look at our standard.
No, you guys, this is cross-examination right here. The defense questioned her first. I was actually kind of wondering that when it started. I thought this is a defense attorney. So that was the defense, and this is cross, because remember a second ago he said, I'll ask her that on redirect, right? So that means he had the direct examination. The prosecution has the cross, and then he comes back again for redirect. So it's kind of weird.
DNA testing, and I showed that I understood that science by completing oral board examinations and written examinations. I also then had to show that I could relay results, those scientific results to a jury by completing moot court exercises. And before becoming qualified, I then took something called a competency exam, where
That's
it's
right,
like
'cause
a
she's gotta
final
take
examination to show that I'm qualified to perform my duties.
Probably was supposed to
During
talk
that accreditation
yesterday.
or that audit process, my training records were reviewed.
Anyways, she probably was supposed to, she had a limited time. She was probably supposed to testify yesterday, but their other attorney objected so many times to the same damn thing over and over and over again, saying the same thing. They wasted about 2 hours on that one.
Qualification, do you have to have ongoing education?
Yes, on a yearly basis, I have to complete at least 8.
Wait a minute. So how is the other guy going to get to do redirect? That's happening today?
Or reading scientific literature.
Do you also have to undergo proficiency testing?
Yes,
This
and a
is actually a
proficiency test is a
prosecution
test that
witness.
we receive from an outside vendor. I process that test like I would any other case and submit those answers to determine if I'm satisfactory or unsatisfactory. This tests not only me to see if I'm still proficient in my qualifications, but it also tests the laboratory process to ensure that we're getting accurate and reliable results.
Now, as you discussed your work in this case, you talked about your work needing to be reviewed by another analyst.
Correct, yes.
And is that true in every single case?
Yes, in every one of our cases, they have to undergo a technical review in addition to an administrative review.
And it sounds like during those technical reviews and administrative reviews, there's discussions between you and other analysts. Is that accurate?
Yes.
And is that an opportunity for training and learning as well?
Yes, absolutely.
And I assume that training and learning goes both directions, that you're learning and you're also helping others understand your thought process, which may train them as well. Is that accurate?
That's true, yes.
The tools you use, are the tools you use validated?
Yes, they are.
And what does that mean to have a tool that you use validated?
So a validation is a thorough testing of a process or procedure. So before we subject any evidence to testing, we ensure that those process and procedures will work within our laboratory. Based on the validation, we create something called standard operating procedures, or SOPs, and these are kind of like cookbooks. It gives us step-by-step instructions on how to do our process and procedures. And then both myself as an examiner as well as the biologists were all trained to those standard operating procedures and tested to those standard operating procedures during proficiency tests.
Now, you've talked about, I think, a couple of the tools you use. One you call StarMix, is that right?
Correct, yes.
And is that tool validated?
Yes, it's validated both developmentally and internally. Developmentally it's validated by the creators of the software. And then we, the FBI laboratory, also tested StarMix to ensure that we could use it within our laboratory and produce accurate and reliable results.
Now, when you say it was developmentally validated, is that in a peer-reviewed study?
Yes, it is.
And is StarMix used, how widely is StarMix used throughout the world?
StarMix is used in approximately 120 laboratories, both domestically and internationally.
I want to go back to some of the questions that you were asked on direct examination. You were asked about an Exhibit 8.4, Baker 8.4, which is the DOJ Ultra, which is the Uniform Language, what does that stand for?
Uniform language for reporting and testimony, I believe.
Okay. It talks about language that you should use and language that you shouldn't use as an examiner and a scientist, correct?
That is correct, yes.
Now, I want to ask you a little bit about what you do when you have a conclusion, like you did in Exhibit 31. Do you know, let's see, the directive from the Department of Justice limits the adjectives you can use to describe the evidence and the conclusions that you reach. Is that accurate?
Yes, it is.
And the thinking behind that is to submit the statistical number and let others decide, meaning the reader decide how they want to describe that number. Is that accurate?
Yes, it is.
So for example, if we can look at Exhibit 31, if you don't mind publishing that. Yes, and that's been admitted, so if we can put it on the screen. And Kimberly, if you could scroll to page 3 when that comes up. Thank you. So item 7 sub 1 is the swabbing from the towel from the rifle. We have the number in a written form in the second paragraph beneath the heading, and then beneath that you have a table, correct?
That is correct, yes.
And
The likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, if you'll, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The results are from 8.1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
Okay, we can take that exhibit down, thank you. You were asked about formal activity level, and you described this as the lab cannot testify about, or you cannot testify about what action left the DNA on the object. Is that right?
That is correct, yes.
Does that mean that an individual did or did not touch? Well, let me ask you this. How can DNA get onto an object?
DNA can get on an object via direct contact, so an individual touching an object. It can also end up on an item via body fluids, such as blood, or through transfer. So if I were to touch an object, and then that object is given to someone else, my DNA could potentially be on that other individual through the transfer of DNA.
And your lab can't, or you cannot testify as to what precise action left the DNA on the object, correct?
Correct, I cannot.
Okay. Same question about time. You can't
Thank you,
testify about the
Phyllis
exact
Watson.
time that DNA
It's always fun.
was
You're
left
a
on
funny
an object,
person.
right?
You make
Correct.
things fun.
But there are some indicators that may give some information about how long and the conditions under which DNA was placed on an item, like degradation.
Yes, degradation or the condition of the item. So again, if a firearm, for example, is in a river, I would expect with the water rushing over that item, I may or may not be able to detect DNA. Also, if there's an item of evidence that is exposed to the elements, something that's been left behind 10 years ago, I don't necessarily expect to recover DNA, but something that may have been left yesterday, I might be able to detect DNA.
An item that has been left in the dirt or has been rubbed in the dirt, could that affect your ability to recover DNA?
It could, yes.
Could it also affect degradation?
Yes.
Can UV rays affect degradation?
Yes, it can.
Does degradation keep you from doing your work?
No, it does not.
Is degradation normal?
Yes, it is.
Does all DNA degrade?
It does, yes.
I imagine if it's kept in a pristine environment, it would degrade less than if it's kept in, or if it's found in a less, or out in the open. Is that accurate?
Yes.
Okay. You said with regard to the screwdriver, there was some degradation. Did that affect your ability to reach conclusions in this case?
No, it did not.
You said on item 7, the towel, or the swab from the towel, there was slight degradation, not as much as Exhibit 8. Is that accurate?
Yes.
Did that degradation affect your ability to reach a conclusion here?
No, it did not.
You're asked about the PCAST report. You testified that that gave guidance on different areas of forensic science. Do you know what year that report was published?
I don't recall the year.
Do you know if it's been within the last 5 years?
No, it is not.
Meaning it's older than that?
Yes.
Do you know if it's been the last 10 years?
I think it was 2016, but I'm not entirely sure. I would say within the last 10 years.
Let me ask you this. Has the science in your area, can I refer to it as probabilistic genotyping?
Probabilistic genotyping is the math in my area, yes.
The science in your area and in your field, has it developed over the last 10 years?
Yes, it has.
And have there been studies that have made suggestions which have been implemented in the field?
Yes.
You testified about Exhibits 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%, and the ratio was 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from twigs, and the 95%, that 95% is assumed from the the Robinson?
When I calculated the statistic, Twiggs' DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the ratio was 11% from the minor and 89% from the major. Is that Twiggs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
You're asked about Baker 4, an exhibit that was titled Baker 4 365. Do you remember this exhibit by chance? I don't have a copy of it, so, well, do you have Baker 4 365? Put that up. And item 7 is the towel, right?
Yes.
Item 8 is the screwdriver.
Correct, yes.
Thank you. You know, it's 5 o'clock. I'm going to wrap up. We can go ahead and take that down. I'm sorry. Thank you for helping out with that. In reaching your conclusions, did you follow the protocols of your accredited lab?
Yes, I did.
And based on your training and experience in following those protocols, did you in fact come to the conclusions described in Exhibit 31?
Yes, I did.
Thank you.
Right, Mr. Burt? And how much time are you anticipating?
He's going to do a redirect?
Right.
How much time
You
you
referred on cross-examination to your training and experience, right?
Yes.
Do you agree with this statement in the PCAS report? Experience or judgment cannot be used to establish the scientific validity and reliability of a metrological method, such as a forensic feature comparison method. Moreover, a forensic examiner's experience from extensive casework is not informative because the right answers are not typically known in casework, and thus examiners cannot accurately know how often they erroneously declare matches and cannot readily hone their accuracy by learning from their mistakes in the course of casework. Do you agree with that statement?
I don't. I think experience, they're right in the fact that we never know the true answer. However, my experience means that I've seen a lot of different DNA. I've seen a lot of validation data, so that does help me come to a conclusion.
Do you agree with this statement by that same report? Good professional practices, such as the existence of professional societies, certification programs, accreditation programs, peer-reviewed articles, standardized protocols, proficiency testing, and the code of ethics cannot substitute for actual evidence of scientific validity and reliability.
I don't think I agree with that either. The science has been heavily validated and tested to show that's reliable. Following protocols that are based on validation, again, shows that my results are accurate and reliable, as well as being proficiency tested.
By the way, you said that that report was not authored by experts, but the head of that group was Eric Lander, who is one of the foremost experts in the area of forensic biology, is he not?
That name does not ring a bell. I don't know who that individual is.
You don't know who Eric Lander is?
No, I do not.
Okay. When did you go to school? What years?
2003 to 2007.
You said that STR mix was widely used and that it's been validated. The PCAST report said the problem is it's been validated by the people selling the product, right?
Developmental validation, yes. Internal validation, no. A laboratory that's going to utilize STAR mix has to validate within their own laboratory.
And the PCAST report said that we need validation data not by the people selling the product, but by independent scientists in order to make this reliable, right?
They do, and that's exactly what happened. There was 31 laboratories that came together in response to the PCAST report and gave their validation data on how they internally validated STAR mix.
And then after that information came forward, the PCAST committee reviewed it, and they said PCAST was unpersuaded by those studies. While likelihood ratios are a mathematically sound concept, their application requires making a set of assumptions about DNA profiles that require empirical testing. Errors in the assumptions can lead to errors in the results. To establish validity with a range of parameters, it is thus important to undertake empirical testing with a variety of samples in the relevant range. And they specifically address the studies you're referring to, did they not?
I believe they did, yes.
Yeah. And then lastly, you said that STR mix is widely used, but as I understand your testimony, you didn't use it and rely upon it for your conclusion about twigs, right? The software told you there was no support there for including them, and you ignored it and decided otherwise, correct?
I did not ignore it. Again, given the type of sample, it was an elimination sample. I compared that individual to the DNA profile that I developed and determined that I could conclude that I could utilize him as an elimination sample.
You said your laboratory was accredited, correct?
Yes.
But you're aware that in 2004, the Inspector General did a comprehensive audit of your laboratory and published a report called the FBI DNA Laboratory Report, a review of protocol and practice vulnerabilities, which found a number of errors in the way that your lab does testing, correct?
Objection. The 2004 study is hardly relevant to this proceeding 22 years later.
It's relevant because he's relying on accreditation to somehow say that these results are valid. This lab was accredited when this study was done.
I'll allow this single question. She may respond, so I'm overruling the objection, and then we'll continue to move forward.
You're aware of that study, right?
No, I'm not.
Okay, thank you. That's all I have.
All right. Anything further for this
Not aware?
witness?
Throw out the DNA then.
Yes, I think there's one follow-up that needs to be asked.
Yeah, it doesn't look like
You were asked that, or you testified that you never know the true answer with field work, correct?
Correct, yes.
And that's compared to ground truth studies where you do know the true answer and you can compare the conclusions that analysts draw with the true answer, the ground truth answer that is the basis of the study. Is that right?
Yes, and that is what our validation is.
Your validation actually studies is a ground truth test, in essence.
Yes.
Okay, thank you.
Anything further for this witness?
Thank you.
Will this witness be excused?
Thank you.
Thank you, God! Thank you!
For the record, before we go into recess.
No, Judge.
All right, having both parties say no, we'll go ahead and be adjourned until tomorrow at 1 p.m. We do not have morning court for this proceeding, and we'll start up at 1 p.m. in the afternoon. Court is in recess.
Well, oh, it's 1 o'clock tomorrow, right? Isn't that what he said? Hold on. I thought he just said that.
Thank you, that's all I have.
All right. Anything further for this witness?
A replay of the sound effect.
Needs to be asked. You were asked that, or you testified that you never know the true answer with field work, correct?
Correct, yes.
Okay,
that's
good. I
compared
can
to
sleep
ground
tomorrow.
truth studies
Yeah!
where you do know the true answer and you can compare the.
This isn't going to be over
conclusions that
tomorrow.
analysts
You
draw
can
with the true
guarantee
answer,
that.
The ground truth answer that is the basis of the study. Is that right?
Yes, and that is what our validation is.
Your validation actually studies is a ground truth test, in essence.
Yes.
Okay, thank you.
Anything further for this witness?
Thank you.
May this witness be excused.
Yes.
All right, thank you, Ms. Baker. You may step down.
Thank you.
Hallelujah!
Does either party need the benefit of the record before we go into recess?
Thanks, Phyllis and Bill.
Having both parties say no, we'll go ahead and be adjourned until tomorrow at 1 p.m. We do not have morning court.
Watch how fast
for
this.
this proceeding, and we'll start up at 1 p.m. in the afternoon. Court is in recess.
You know, the best one in the world is the way he hit the gavel after the last break. It basically it sounds very similar to this. He sort of hit it and they sort of let it flop around. It was so good. Oh God, that was good stuff, man. That was good. I love. You ever watch those highlights from that movie, Draft Day, man? I can watch that over and over again. It's crazy. All right. Well, anyways, thank you to we had Megan Kelly, not the Megan Kelly, Allie Cake, although she could be the Megan Kelly in some other world, so I don't know. And then we have Allie Cake, Linda Cosma, and Linda Cosma was 40 months. She said 3 years, but don't sell yourself short. That's actually 3 1/3 years, okay? Then we had Linda Cosma, Phyllis Watson, objection. Yeah, that's how it was going early. Allie Cake, Wild Bill Wassman, Tracy Von Brott, Born to Raise Hogs, Stevie Lynn, Megan Kelly, the Megan Kelly in her world, Cinnamon Sin Freak, KMTX or KME, Apatheticate. I like that name. We say howdy here, and then they proceeded to say hello. Alley Cake, Wild Bill Wassman, Apatheticate, Wild Bill Wassman, Alley Cake, Phyllis Watson. Very insightful conclusion you came to with the scant info you were given at the beginning. Almost like you were there, Gray. Maybe he was. He's an insider. Perfectly sound reasoning and immaculate representation. Thank you. Well, thank you. And if, by the way, if you're sort of new here and if you had been watching our channel since the beginning, you would have been like amazed at how accurately every single thing that's been presented in terms of Tyler Robinson's movements, etc., we had way earlier. Alley cake, Mama for coffee. We used to have a Mama 457 rows, remember that? And then CJ, Phyllis Watson again, thank you. AOC TW, Grinch 45, Roger Smith, Christy Roberts, thank you for the detailed coverage. I've been watching since Delphi. I think I read all these when they happen, but and you covered the bridge guy accurately and earned my respect. Glad to see you showing this live. Thank you. That's this one here. Thank you. And then Anne Marie, T Girl Michelle, thank you for all you do. Best channel on YouTube. Yeah, well, it's the best channel on YouTube that nobody sees. That's all I can say. And then Dr. PIV, Alley Cake, Phyllis Watson, Alley Cake, Phyllis Watson, Six Kids UK, Whiskey Boots, Lisa V, Megan Kelly, Phyllis Watson, Joy Orlando, Phyllis Watson again, Anne Marie, Megan Kelly. I think there was a 5. Some of these right here are 5. So it's Phyllis Watson, Anne Marie, Megan Kelly, K-Me, and then I did one. And then Carl with the C gifted 20 memberships. Made a big difference. We wouldn't even have made the minimum goal had he not done that. Believe it or not, after 8 hours, that's pretty crazy. Then we had Wild Bill Wassman, Phyllis Watson, Apathetic It, Wild Bill Wassman, Phyllis Watson. And then, oh, look at that, Robin in the Hood. Hey, you found it. I literally had to get on my computer. Very cool. Awesome. Well, thank you. Really appreciate that. And Robin the Hood, another $1. Right at the buzzer there. I guess 12 looked weird. Let's see. Anyways, thank you so much, you guys. And I was thinking of coming on later. You know, I thought it would be cool to come on later, maybe, I don't know, 7 o'clock or my time or something, and put the new surveillance in sequence with the videos that I've already made. Don't you think that would be pretty interesting? Or I might even make a different one. I was thinking of making a video where I just put like a dotted line where he's walking and then show the video when it's available instead of from the eye view. I mean, that's cool and everything, but it would be shorter. I think that'd be kind of cool to do, though. Put it all together, all the new video in sequence with what we already got. What do you think of that, you guys? Okay, well, we'll see you this evening. All right, here we go. Thank you for watching Gray Hughes Investigates on YouTube, where we cover true crime using logic, reason, and common sense. Thank you all very much for watching, and as I always say, until next time, be safe out there.
Evil can never be dead enough. And some of you make shit up.
Hey, Allah, oh,
right, see you guys.